for orders, I cannot list on the next week because notification has been circulated by order of Chief Justice.
My lord, that has to be listed on 11 as per the order, the last order. But not is list out.
After vacation or this week? Next week to hobo, no hobo, na? Not next week. After
week?
vacation or this week?
This week, Friday.
This week, data delay. Friday, on Friday.
Please, Your Lordship. New matter, matter may be listed on 19. This matter is very urgent. The PW1 has closed and subsequently very short date, the DW also closed. Now matter is fixed for argument on 22. That's why matter may be listed on
Argument on 22.
22.
Okay, on 22. Motion matter
Motion matter.
on 22.
May please, Your Lordship. Item number 9, my lord.
Hmm.
My lord, today some difficulties, my lord. Next week, my lord. Item number 9.
Have you taken consent from the other
No,
side?
there is motion matter, my lord.
For motion matter.
May please, Your Lordship.
It will very,
Next week.
Learned Counsel, Mr.
VK Borwa, my lord.
V.K. Borua
Lordship.
has prayed for adjournment.
Next week.
List the matter after
1 week.
1 week.
I love it.
May please, Your Lordship. I beg to mention on RSL Lordship. It's a fresh matter.
Hmm.
The matter may be listed on Monday.
Yeah, please, Your Lordship. I beg to mention for listing of a MSc appeal, where I have filed an IA. Matter will be listed on 19th Lordship for orders.
Friday 19th. IA for what? To withdraw the money?
No, there is no direction. Stay was granted, but no direction was granted for deposit of that 50% amount for modification
Then
of
we
the
list it after vacation. After vacation.
immediately after honor
Yes, 14th October.
obliged.
My lord, this is the interim application, my lord, for consideration of miscase for condemnation of delay. The matter may come up on Monday or Friday, my lord. Because claimant has already, judgment has already passed in favor of claimant, my lord.
No, can't help it. After vacation or this week?
This week, my lord.
This week, painigi. See, this week,
Friday.
see, I won't be sitting in this bench this week, so I won't list this week. I won't be sitting in this bench. Or A2 hafta, no, A2 hafta.
Wednesday, my lord.
So, 19th or 19th.
May please, Your Lordship. Lordship, I am praying for listing. This is MSc appeal. Lordship, it's sharing matter. 2022 matters, Lordship. Lordship, after vacations, any date, Lordship. Lordship, kindly keep. Lordship, similar prayer is also there, MFA, Lordship. It's also related. Lordship.
May please, Your Lordship, I beg to mention 2 CRP matters. One is in motion and one is for orders. That will be listed on
Motion can be
Friday.
listed next week.
On
The
Friday.
info motion can be listed next week, but orders cannot be listed. We'll be listed after vacation.
Lordship, can you list the orders on this Friday?
Orders for Friday will be difficult. Not on
It's a
Friday.
bit urgent, Lordship.
See, we have 2 more days. More urgent matters will come up for 2 more days. After vacation.
It's a bit urgent.
Motion will listing on next week. Orders we cannot list on next week. This notification is circulated by order of Chief Justice. We cannot list orders next week. Motion we are listing it next week.
On next Monday, 22.
And orders matter will come after vacation. The date is a DD, 14th October.
May please, Your Lordship.
Hmm.
Lordship, with the concern of the other side,
Hmm.
we have a joint prayer in respect to item number 41
Hmm.
of the hearing. Lordship, on last occasion, Lordship was pointed out that the names of the learned counsel were as well as not shown.
Hmm.
Today he is appearing, Lordship, the matter was sent for mediation because a talk of compromise is going on between the
Hmm.
parties and there is every possibility that
Sure.
it will be resolved. Item 41, Lordship, hearing matter.
Learned Counsel, Mr. S.M. Krishnapra is present
Lordship,
for the appellant, and Learned Counsel, Mr.
I am for PK Das. on behalf.
P.K. Das is present for the respondent. Both the parties have submitted that there is an element of settlement in this matter. This matter is therefore referred for mediation. The mediation where
Before the Guwahati High Court
Before,
mediation center.
referred for mediation to the mediation center at Guwahati. Notices may be the mediator may issue notices to the parties for appearance on a date to be fixed by the mediator. List the report to be submitted on 2 months or date, 2 months.
1 month will be enough because there is already a compromise.
Report to be submitted on the outcome of the mediation on 7 November.
Lordship, I have one another prayer for listing of an IA for withdrawal of the amount, which is for deposit for the registry of this court, Lordship, MSc appeal, Lordship. Any day, Lordship, as per convenience of this court, Lordship. Before vacation.
We'll have to list it after vacation, not
Lordship,
now.
can it be before vacation,
No,
Lordship?
no,
Because,
no,
Lordship,
because
there is two.
That person is very old.
Yes,
person
Lordship.
very
Yes,
old.
Lordship. Is it about 67, Lordship?
67,
That take-
67 be very old. Who, just see who are serving as president and prime minister of India.
If possible, Lordship,
May I please, Your Lordship? Lordship, I pray for listing an interlocutory application which is filed for withdrawal of deposited amount, Your Lordship. That matter has been filed on 26th of August, Your Lordship. But since this, it has been not listed. So Friday, possible for Your Lordship,
Withdrawal amount.
15, withdrawal amount. I'm so obliged.
May I please, Your Lordship? I beg to mention 3 MA face map. It's not listed from 2013 on in hearing stage. After vacation, if any date can be fixed. 22nd of
3 date, in fact, 3 ML.
May I please, Your Lordship, I beg to mention for CRP.
Hearing stage. Just a moment, just a moment.
May I please, Your Lordship, I beg to mention for listing of civil division petition, Lordship. It was orders column, Your Lordship.
Orders. When do you want?
This week. 19.
Orders for what?
Lordship, it was filed for IO Lordship, filed under orders 14 rules of 27 of CRPC addressing the additional services matters.
Under order?
It was.
Hmm.
Lordship. it
For
was
what? IA for what?
IO Lordship. Filed under order 14 Lordship. Rules of 27 of CRP Lordship, for the addressing additional evidence.
No. 15th October.
May I please, Your Lordship? Also, I beg to mention for listing a IA Lordship for correction of the order Lordship. The Honorable Court stayed the impugned judgment of the lower court, but due to mistake typographical error, the title suit number is wrongly written as other Lordship. So I may be allowed
When do
to
you want?
Friday Lordship. Correction of Lordship.
May it please, Your Lordship. I beg to mention this second appeal for listing after vacation on 13th October. Obliged.
May it please, Your Lordship. I beg to mention a CRP for a motion, Lordship. May it be listed tomorrow, Lordship, because
Next week. Next week,
Lordship,
we are listing everything for motion on next week.
Lordship, reason is for mention is that Lordship, a portion of the land after execution, a portion of the land and of the decree holder is ordered to be attached, Lordship. So I am
After execution, it has been
after
executed.
execution, Lordship.
It has been executed.
Executed, Lordship. Now there is a situation is that the plaintiff,
Monday.
Lordship,
It has
Friday,
been
at least,
executed, see,
Lordship,
all
yes,
executed Monday.
Friday, Lordship. Already numbered.
No, not on Friday.
Already numbered.
Monday.
May it pleases your lordship, I beg to mention for listing of a matrimonial appeal lordship.
At which stage?
Just notice was issued lordship.
The motion stage.
Yes, lordship.
When do you want? Next week?
Next week, lordship. 24th, little inconvenient. Can it be on 25th or maybe on 23rd? Deeply oppressed.
Item number 1 for withdrawal.
Let me go. I'm good at it. Let me go.
Yes, you want to withdraw
Yes. I'm not a respondent, madam.
for the respondent. So it will go back to that early stage then.
Okay.
Reversible order or concurrent orders?
Actually, we both party have come to a settlement, madam.
Then you will settle before the appellate court, first appellate court,
First appeal,
or before the
already
trial court.
withdraw.
Okay. Learned counsel, Mr.
SK Singha. SK Singha.
S.K. Sinha is present for the appellant, and learned counsel, Mr. B. Sharma,
G Pathak.
G. Pathak.
On behalf of B Sharma.
On behalf of learned counsel, Mr. B. Sharma is present for the respondent number 2.
Two.
Both the, whatever respondent number 1.
No, sole respondent.
For the- Here is written R2, that is why.
Yeah.
Your name is shown as advocate for R2, sole respondent.
Abu Tahir was there. Was he was
Abu Tahir passed away.
passed
Yes.
away, and Likin has written.
Yes. Yes. Respondent Minanda Kuburu Satish Kumar.
That is good.
Minada Kuburu Satish Kumar.
That is good.
নামটো লিখি দিবা। Both the parties have amicably settled their dispute, and the appellant has prayed for withdrawal of these appeals. And appeal is hereby, after hearing both the sides, appeal is hereby dismissed on withdrawal. Trial court record as well as the original record of appellate court to be returned back. Nani? Record nai. Okay, now I to cut it. Yeah, I'll check and see. Then I'll, if any correction is required, I'll correct it.
Well,
Have you did discharge লিখে দিবা?
Item 2.
এই হেৰি ৰেকৰ্ডৰ লগত দি দিও, মই চেক কৰি চাম কি আছে কি নাই, অৰ্ডাৰটো কাৰেকশ্যন কৰি দিম।
I think this is suspended matter, your lordship, and the FOXO is there, your lordship. So at this stage, notice may be issued, your lordship.
Okay.
And before
Learned
vacation,
counsel. Yes, yes.
and the date may be fixed before vacation, your lordship.
Learned counsel, Mr. A.M. Khan is present for the petitioner. Learned additional PP Ms. Nanda is present for the state. Petitioner to take steps to issue notice to the respondent number 2. Returnable on, when do you want?
27
27 on.
or 25.
Which Thana?
This is Hathi.
Hattigaon, PS.
Okay, on 25.
Oh.
Meanwhile, call for the scan, Shashi has been submitted.
Yes, Ashish.
Meanwhile, call for the scan copies of the trial court records, along with the scan copies of the entire case diary.
All right.
Yes, yes.
But the transfer petition, praying for transfer of a restitution of conjugal rights petition filed by the husband, that's it. Section 13 petition
Restitution.
filed, yes, that's all.
From which court to which?
From
court?
family code, principal judge, family code, Kamrup Metro to Borpeta, principal judge Borpeta. Family code Borpeta, Lordship.
Case is pending at which stage?
A appearance, Lordship.
Appearance stage,
Yes, on 29/9, probably it is fixed for appearance. The part.
evidence,
No, appearance. Lordship.
appearance.
Yes. The wife, who is the petitioner before your lordship, is yet to appear before
This
the,
is a divorce case or
no, restitution of conjugal rights.
or restitution of?
Yes.
conjugal rights, okay.
Both the parties, they resides outside the jurisdiction of principals of family code, that your lordship will find at page 16. The cause title filed in the petition of restitution of conjugal rights petition. The petitioner therein, who is the husband, he is a
We'll-
resident of,
We'll issue notice.
lordship may stay the proceeding. Otherwise, she will, have-
Evidence, appearance stage,
lordship.
appearance stage, why should we stay?
Lordship, because it is difficult for her to appear because the wife, she resides at Borpeta. she has filed two cases before Barpeta, wherein the respondent hearing, the husband, he is appearing therein. So now he has filed a petition, who is a resident of Kamrup Rural, and he filed a restitution petition at Kamrup Guwahati. This is just a harassment, Lordship. Because the conditions which are in section 19, those are not absolutely fulfilled because the marriage was solemnized. I will just,
Stay is not required. Stay is not required.
otherwise she will have to appear, Lordship. That is the difficulty.
No, this is not a case.
Lordship,
We do not want a LCR.
Lordship,
We do not want a LCR also.
Lordship. My interim prayer may be kept open, otherwise, Lordship.
What kind of observation you want?
That the interim prayer of the
The prayer,
petitioner is kept open.
interim stay will be considered on the next date fixed.
Yes. Lordship, may kindly fix a date. So that I can inform the family court that this honorable court is adjudicating the issue.
On 22nd of.
Lordship. Obliged, Lord.
Wait, please, Your Lordship. Lordship, I have come against the impugned order dated 24th of July 25, which is at page number 75 of my petition. Page 75.
Yeah, please read.
Yes, Your Lordship, if I may in brief, apprise the court what has happened in this order, Your Lordship. What has happened? I am the plaintiff in the suit. At the time of the decree, and it was it went for execution. The suit land is, Your Lordship, not identifiable today. So because, Your Lordship, the plaintiff is claiming his right on the basis of a title sale deed, and in that sale deed, the boundaries of his land are very different. That is for 2 bigha and 8 chataks of land. And the sale deed which I have purchased through, and that boundary is also different. So today, when he is going to execute the decree, the land as per se on the ground is not identifiable. And today, when the bailiff had come for the execution proceedings, at that time it was found that I am already in possession. I have been staying there since the last 20-30 years. Structures have been built. So my humble prayer before the learned court below was to identify it by appointing a commissioner. That was my basic prayer. So that at least the identification must be done.
Why the boundaries are not describing the sale deed?
No, that's what the exact. If I may show your lordship, page number 20. If your lordship may kindly turn to page number 20. The plain. Schedule of the property.
This order, impugned order is page 75.
Impugned order is page 75. My section 47 petition for identified.
Okay.
Page 75.
Oh, this is in the decree.
Decree, Your Lord.
So why should we go back to the suit?
Your Lordship, I'm not saying to go back to the source. My humble prayer is that the identification of the land as per se needs to be done, because today what has happened when the decree is going to
You
be
want to show me the sale deed?
The schedule of the property, basically.
Page
In
20.
page 20, the plaint of title suit was filed against me. Page number 20. So if your
Yeah, the
lordship,
schedule here.
schedule, yes, the lordship. District Kachar, Barakpur, Moja, Ambikapur, second RS Patta number 72, Dag number 190, land measuring 2 Katha, 8 Chatak, bounded on the east by embankment, west land of Sri Sudhanshu Das, north by lane, and south other land of defendant with incomplete RCC structure. So this is the suit land which he is claiming to be his, the plaintiff. And your lordship.
You are the plaintiff.
No, I am the defendant.
Oh, you are the
I am
defendant.
the defendant. So, your lordship may kindly turn to page number 64 of my petition before the trial court. I am claiming my right on the basis of a sale deed dated 31st of August 2012. That is at page number 64, para 3
Mm.
in the petition. And if your lordship will see, if I may read, if your lordship may kindly see the boundaries which I am in possession of right now via sale deed number 2159 dated 2012. On the east, there is a path. On the west, land of Supriti Nath. North. So your lordship, the
Pair number 3 is your schedule, is your land.
yes, your lordship.
So this is different land.
Different. So there are certain
Mm.
inconsistencies regarding the decree which has to be executed as of today. So my humble prayer was to identify, appoint an Amin commission and identify, so that I'm ready to, if any of my land is encroaching on the plaintiff's rights, I'm ready to give. But as of today, I have been staying there, and I have been staying actually prior to the plaintiff. I have purchased
Where's the
a
decree?
decree is at page number 28. It starts at page number 28. Basically, why this issue has come up, because the vendor is the same for both
Decree
me.
is the page number 28.
28, your lordship. Decree, judgment is at 28, and the decree will be at page number 55. Page 55, the decree.
Schedule 1 is a decreted land, no?
Yes, your lordship.
Which is not similar to your land.
No. The decree,
Okay, let us, please read the impugned order.
impugned order, I will read the impugned. It is a page number 75. Petitioner judgment dated, the opposite party, decree duly represented, today the date is fixed for necessary order. So I will read it. By this order, the court is to dispose of petition number 46 of 2 instituted under section 47 read with section 151 of CPC filed by the petitioner. Judgment dated. Copy of the aforesaid petition is received by the opposite party decree holder under objection, and accordingly written objection was filed by the opposite party, where they specifically denied the maintainability of the said petition and further stated that at the time of granting the decree, all questions arising between the plaintiff and the defendant petitioner were properly determined, and there is no point to discharge or satisfaction of the decree to be determined by the court. Now let us discuss the petition of the petitioner JD in brief. The petitioner acquired right, title, interest and possession in respect of the land measuring an area of 1 Katha 8 Chatak covered by second RS Patta number 72 Dag number 190 appertaining to Moza Ambikapur so and so of Silchar jointly with one Navadip Das, purchased by a registered deed of sale via deed number 4048 dated 11th of October 2007 from Sri Rajendra Das with definite boundaries. In addition, stated that when Narayan Paul was in exclusive use and enjoyment of his purchased land measuring 5 Katha 4 Chataks, he sold out of land an area of 2 Katha 12 Chatak covered by same Dag number Patta number, well, with specific boundary by registered sale deed by deed number 2159 dated 31st of August 2012 of the Office of Deputy Registrar Silchar and delivered possession thereof. Petitioner further states that in the aforesaid manner, he purchased ownership right of the land measuring an area of 3 Katha 8 Chatak covered by second RS Patta number 72 Dag number of Moza Ambikapur, parts 8, and the said purchased land is in one compact block and there is no partition amongst the petitioner, judgment debtor, and his co-purchaser Navadip Das. However, the petitioner judgment debtor has been in exclusive possession and enjoyment in respect of his purchased land measuring an area of 3 Katha 8 Chatak as per their mutual understanding arrangement with the said Navadip Das. It is that the OP decree holder instituted title suit 153 of 2012. Now it's a defendant plaintiff's case in the court of Munsif number 1 Kasa Silchar against the petitioner JD as principal defendants and against the said Narayan Paul as pro forma defendants for declaration of right title interest and for recovery of khas possession in respect of the Schedule 1 land of the plain measuring an area of 2 katha 8 chatak. And also for cancellation of register seal deed number 2159 dated 31/8/2012, alleging that the OP decree holder purchased the said land from pro forma defendant number 2 Narayan Chandra Pal. So this is the main contention, same portion of land like I am saying I have purchased the land by seal deed number 2159. So plaintiff has paid for cancellation of the same seal deed. But if your lordship will go into detail in the sale deeds, the two sale deeds are having two different set of boundaries, which clearly, so my contention is that the land which the plaintiff is claiming is a identification of the land is not as per se done on the ground. And so today, when the bailiff had informed me regarding that execution, so my property, which I have been staying there since so long, it is bound to get affected. So my humble prayer was to identify before, because today, actually the plaintiff's land, it has been so many years. Prior to that also, they had filed a suit in the year 2012 with the pro forma defendant, who is the pro forma defendant in the present suit. So your lordship, that point of time, they did not take possession, they did not execute the decree. Again, they have presented.
So this was the order passed by the civil judge junior division.
Yes, your lordship.
Then why didn't you appeal in the lower
Your
court?
lordship, what has happened is that this vendor, Narayan Paul,
Hmm.
he is the vendor for both me and the defendant. So he had sold me the land and to the defendant also.
I understand.
So what has happened is that he informed, because he had sold me the land and I was already staying on a different plot of land on the same dag number, patta
So
number.
you have a forum there down, you have a forum to prefer this petition in the, I think.
First
before
step. For a first service, like after,
Yes,
the-
yes.
yes, for an
the- For
appeal.
the civil judge senior division.
Senior division.
Yeah.
But your lordship, what has happened, this Narayan Paul, we were never informed because he had told us, because he had sold us the land, he took charge and he also in the meantime expired long back. And that time his legal heirs is also not included in the suit, and it went on the suit without any information. So now after so many years, when the execution court came, because there was no option, now if I go, whether the executing court, whether the court below will enter in, because it was too late, I became aware of the same. During when the bailiff had come for execution, that time I became aware that the suit has been executed.
Please read the entire order.
Yes, your lordship.
You want to stay?
I want to stay.
I want to find out, please read the
Yeah.
entire order. If stay can be granted.
Point number 9.
Because you see, you have a forum out
Forum,
there
yes.
to prefer this petition, but you have come straight away to the High Court.
That is, yes.
Under which provision?
I have
Same
filed
provision,
because
under same provision which
Yes.
you could have preferred the petition
Ye-
in the lower court.
because they had filed an executing petition, I came against that. Because my petition under 47 was dismissed, I am aware of that I could have gone for an appeal to the civil, but I was not aware of regarding the pendency and when the decree was given. I became only aware of the facts that a suit and a decree has been passed against me.
Where have you mentioned this?
I have mentioned it. In my petition. Paragraph number 5, page number 66. If I may read, your lordship. That the pro forma defendant number 2 of the suit, Narayan Paul, as one of the vendors of the petitioner, assured the petitioner judgment dated.
No, no. The reasons where have you mentioned in this petition, revision petition?
Not revision petition, because this is a part of the, I have challenged that impugn order, the petition which I had filed in the, below the trial court. In that,
That will come in the order, that will be included in the order.
yes, that
Then
is
you
it.
can read the order.
Okay.
This you have not mentioned in the revision petition. Why you have preferred the petition
Revision-
here instead of before the?
See-
Yes,
Because the revision petition, your lordship, I have not mentioned, because the revision petition, I have come before this honorable court against the impugned order dated 24th of 7.
Mm.
And there my prayer was to appoint an Amin Commissioner for
24-4.
24/4/2000.
Amin Commissioner, yes.
Yes. So your lordship,
This was rejected.
this was my simple prayer. So before the High Court, I have not come against where my prayer was rejected, stating
Hmm.
that I have not preferred a revision, or my prayer was taken on the merits of the case, stating that the identification of the land is not required before the executing court. So that was
Just a moment. CPC don't think. According to you, appeal does not lie.
no appeal lies, your lordship, but we were by the time
Hmm.
we were informed of the decree, it was at the time of execution, because the vendor had taken charge of, because he had sold us the land, he was pursuing the case.
Okay. All right.
So that was, we were not informed of.
Okay, I got your point.
And it was too late at that time to approach, because already the executing court had, and if I had not acted like, immediately, if I had not preferred before this High Court, at least some protection was needed at that moment. So
So, have you mentioned about that you were not aware in the petition itself, in the revision petition itself?
in the revision petition, I have not mentioned, but all the documents are part of the record.
Okay,
So,
all right.
and
You read up to paragraph 5, I think.
5. Paragraph 6 is over here. Now paragraph 7 will start. Petitioner further states that in the aforesaid manner, he purchased ownership right of the land measuring an area of 3 katha, 8 chatak covered by second RS patta number, dag number 72, dag number of Moza Ambikapur, part 8. And the said purchased land is in one compact block, and there is no partition amongst the petitioner, JD, and his co-purchaser Navadip Das. However, the petitioner judgment debtor has been in exclusive possession and enjoyment in respect of his purchased land, measuring an area of 3 katha 8 chatak as per their mutual understanding arrangement with the said Navadip Das. If I may, it is that the OP decree holder instituted title suit number 153 of 2012 in the court of Munsif number 1 Kachhar Silchar against the petitioner judgment debtor as principal defendant and against the said Narayan Pol as pro forma defendant for declaration of right title interest for recovery of khas possession in respect of the Schedule 1 land part plain measuring an area of 2 katha 8 chatak, and also for cancellation of registered sale deed number 2159 dated 31/8/2012, alleging that the OP decree holder purchased the said land from pro forma defendant number 2 Narayan Chandrapal. Paragraph number 9. The petitioner also asserts that he was not aware of passing any ex parte decree against them, and he came to know when the bailiff of the civil court on 10/9/2024 visited the residential premises of the petitioner situated on the Schedule 1 land and informed that a decree has been passed in respect of the decretal land ex parte against him, and such he is to vacate the premise. On further inquiry, the petitioner came to know that the pro forma defendant number 2, Narayan Pol, expired long back, and his legal heirs were not substituted in the said suit in his place, and thus it appears to him that in collision with the pro forma defendant number 2, Narayan Chandrapal, and the plaintiff decree holder obtained a fraudulent decree with an intention to oust the petitioner from his purchased landed property. However, the petitioner stated that no decree was passed for cancellation of the sale deed of the petitioner judgment debtor as prayed for. The petitioner judgment debtor asserts that the description of the land as given in the execution petition and the decree is vague and not identifiable in the locality, and as there is no existence of any such land as per the boundaries as given in the plain and execution petition, and the petitioner judgment debtor has been in possession of his landed property since the time of purchase by constructing houses thereon with compact block, and therefore without a suit for partition, the plaintiff decree holder is not legally entitled to ascertain his legal share of decretal land, if any. It is also mentioned by the petitioner that the vendor of the decree holder plaintiff sold out his purchased land measuring an area of 5 katha 4 chatak as aforesaid to different persons, including the petitioner, and there was no partition amongst the purchasers, co-purchasers of such land.
All right, then this is the dispute,
Dispute
and then your prayer was rejected.
rejected.
Where is the last part of the order?
Last part of-
Rejecting your prayer?
Page 83. Oh, not there, no. Paragraph number 16, page 81. Now, if I may read, Your Lordship.
Hmm.
Now, after hearing the submission and perusal of the said petition of the petitioner judgment debtor, along with certified copy of the judgment and decree, this court understood that the said petitioner judgment debtor, as principal defendant, had filed a written statement in title suit number 153 of 2012, where petitioner judgment debtor stated about the purchased land denying the right title interest of plaintiff decree holder. But there appears no mention or question on partition of the land by petitioner judgment debtor as apparent from the written statement and certified copy of judgment in title suit number 153 of 2012. In fact, no such issue was raised before the trial court during adjudication of the title suit. Moreover, the petitioner judgment debtor, even after filing the written statement, did not lead any evidence to disprove the title of OP decree holder. Then subsequent to that, filing the petition, 46 under section 47 of CPC for the first time raised the point in manner that the petitioner judgment debtor has been in possession of the landed property since the time of purchase by constructing houses thereon with compact block, and therefore without a suit for partition, the plaintiff decree holder is not legally entitled to ascertain his share of decreed land, if any, and that the vendor of the decree holder plaintiff sold out his purchased land measuring an area of 5 kata 4 chataks for different persons, including the petitioner, and there was no partition amongst the purchaser, co-purchaser of such land. To understand the same in the relevant portion of the judgment in Periamal that through legal representatives and others versus V. Rajamai, another citation 2000 is reproduced below. A harmonious reading of section 47 read with order 21 rule 101 implies that questions
So, I cannot grant stay, you see. You have not raised the issue through a written statement.
Your Lordship, that is my contention, Your Lordship, because as I have already submitted for the learned code below, I was not aware of, only when the bailiff had came at the last moment, there are some latches on my part, no doubt about it. But now what has
So
happened?
why didn't you mention in the written statement, the schedule was given in the suit, title suit, then you have filed a written statement.
That is what, Your Lordship, this Navadip Das, who is the vendor for both of me and the petitioner, he sold the land and he took charge. The fact that, okay, I will do the case and on behalf. And in the meantime, he also expired. Thereafter, it was, so at the moment, Your Lordship, if some protection may be granted, at least identification of the land if may be done. I'm not saying that I should not, if I have encroached any part of the land, I will move away. But the thing is that I have been staying here and pursuant to this to sale it in the year 2007. Since the year 2007, I have been staying there. Both the present plaintiff has also come prior to after me in the year 2012.
Plaint.
Yeah, yes, Your Lordship, the plaintiff. His sale deed was executed in the year 2000.
Where is the plaint? Where is the plaint and your WS?
Plaint is at page number 15. Because it is obvious that
I
person.
cannot find any error in this order.
Your Lordship, I'm not saying as such there is an error, but what I'm saying is that when even the learned apex court has also said the identification of the land must be done before, because what the plaintiff has sought as a relief is that he is saying that I am supposed to get this much portion of the land. But today on the ground, there is no such, his boundaries which he is claiming to be, there is no such land in existence. So when the decree is going to be executed, some identification needs to be done. Because already I'm staying there,
The
other people
decree
are
is
there.
very properly identified. The land has been very properly identified in the decree.
Your Lordship, if you see my sale deed, agreement for sale, which he is praying for cancellation of, that sale deed.
When is the date fixed for, when was the writ issued?
Writ issued. Now, Your Lordship, there is, because we have filed this, I think the next date, there is some time before the
There's some time. That bailiff has gone to your place.
bailiff had gone on September. in the month of September 24.
I don't know, I cannot find any error in the order, and then you have, this is the plaint, and this plaint, this was filed in the year 2012. We have purchased the suit lane in the year 2007.
I have purchased the Suitland, there are two Suitland, not two, I am staying there from the year 2007. And then I purchased in the year 2012 because this Narayan Paul, the vendor, he had sold, he had 5
Narayan
patterns of
Paul is
lot.
the vendor, yes.
Vendor, he has sold 2 Suitland, one to me and the other to the
To
plaintiff.
the plaintiff.
Yes, so today, because so many hands have exchanged since the time that the agreement was sealed, it was executed. So today, your worship, that Suitland is not identifiable. That's why they have previously also, lordship, if you're, if I may show,
You did not file an appeal also,
that is that and lordship.
and then during the decree you have come and now you're asking for stay. Any return statement also, I don't know. You convince me on the next day. Today I'll go through everything. Huh? I'll go through it, convince me, this is at the stage of motion. Come on next week. See,
Some latches, I like to admit, to be fair, there are not only some that glaring latches on our part because we did not file an appeal. And not to be fair with the court, I'm not saying that, but today what has happened, because I was in the
it's
blind.
not an ex parte decree also. Had it been an ex parte decree, come on next week.
Yes.
Motion, we have motion on next week also. I'll not write down hard. I'll just write your name, record your name. What is your name?
GR Datta.
Learned Counsel, Mr. GR
Datta.
Dr. is present for the petitioner. List this matter next to the detail. 25th September. Item 5.
Deeply applied.
May it my lord, very short matter. In this particular case, I filed the application for partial degree under order 12 rule 6. That petition was rejected by the learned tribe. That order you also will find at page 14. And relevant
This petition is against what?
for decree on admission, ma'am. Under order 12 rule 6, my lord. Your lordship will find the order at page 14 and relevant portion starts at page 17.
Commercial court.
Commercial.
So you are asking for stay,
No stay.
because the stay cannot be granted.
No,
That's
no,
what-
not granted,
Uh,
because that proceeding would be stayed. That's why I don't want that
Okay.
proceeding.
It cannot be granted also. Yes, anything else?
Uh,
Will
I-
you notice then, motion stage? Learned Counsel, Mr. O.P. Bhatti is present for the petitioner. Petitioner to take steps to issue notice to the respondents returnable within 4 weeks. Okay. Item 6. List accordingly.
The background of case is this, my title should file, my lord, for right, title and interest. And also for declaration, a decree declaring that I am permissive occupier. The defendants are permissive occupier on the shoot land. Another thing is the permanent injunction. Permanent injunction. So shoot is of 2023. Now your lordship, what happened? I could not file the written statement in time. So I filed a petition. Filed a petition that time may be granted. First petition was allowed. Second time I again filed petition because I could not collect some documents. So that petition was rejected and case was fixed for PW. Thereafter, my lord, I filed the third petition with WS. Along with WS, I came that I filed the WS, so the earlier order may be set aside and my WS may be accepted. That is in nutshell is the case. Now your lordship would be pleased to see my WS, that is at page 28.
this was not accepted.
My lord,
Your WS was not accepted.
written statement was not accepted.
Okay, why, what is the point of seeing the written statement?
My lord.
Let's go to the order.
My
Impeached
lord,
by
your lordship would be pleased to turn to page 43 onwards,
page 43.
order dated 4/6/2025. May I read the order?
Yes.
So, my lord, plaintiff, page 43. Plaintiff of defendants are duly represented. Defendant on 6/5/2024 by petition number 427B24 prayed to allow to file the written statement on ground that if the same is not allowed, then defendant side shall suffer irreparable loss, and accordingly their fair adjudication of the case shall be hampered. Here, my lord, I want to place before your lordship that irreparable loss in numbers of decisions, Supreme Court as well as High Court, my lord, it is held that if land is involved, that will be treated as irreparable loss. Because, my lord, value of the land will increase like this. That cannot be substitution. So irreparable loss, if we define, it will related to land. On perusal of the case record, it appears that the statutory period of 90 days to file written statement has already expired on 27/2/2024, as calculated from 27th of November 2023. That is the date of issue of summons. Careful scrutiny of the case record also reveals that 6/5/2024 is 159 days, as calculated from the date of receipt of summons by the defendant, that is from 27th of November 2020. Perusal of the case record also reveals that the learned counsel for the defendant has not filed any application praying for condonation of delay under Section 5 of the Limitation Act. Here, your lordship, I want to submit before your lordship, as per Article 137, if there is no prescribed period of limitation, in that case, it is 3 years. In the schedule of the Limitation Act, my lord, there is no prescribed period for petition under Order 8, Rule 1. There is no prescribed period in the Limitation Act. Otherwise, I will go to
Order 8, Rule 1.
Order 8, Rule 1. That is submitting of written statement. So, your lordship, Article 137 says of the Limitation Act that if period is not prescribed, it will be 3 years. So, my petition, my lord, there is delay only one day.
30 days, 90 days.
My lord, the 30 days, 90 days, my lord. Your lordship will take this Order 8.
Within the Order 8, Rule 1, the defendant shall within 30 days.
Yes, my lord. And that may be expanded on to
That
90 days.
prescribed period.
Yes, my lord.
Then
My
how
lord,
can we stretch to 2
my lord,
years?
that is their prescribed period, but limitation petition is to be filed under Limitation Act. That is not prescribed. That is my humble submission. If your lordship go to Section 5.
So why should we go there?
My lord.
It's not required.
My lord.
No,
No, my lord. Here, if your lordship, if
no, it's not required. Please read the order.
my lord.
Let us continue with the order.
My lord. On perusal of case record, if 90 days filed written statement has already expired on so and so, my lord, 59 days. Perusal of case record also reveals that learned counsel for the defendant has not filed any application praying for condonation of delay under Section 5 of the Limitation Act. In this regard, this court would like to reflect the finding of the Honorable Supreme Court so and so. Extension of time may be allowed if it was needed to be given for circumstances which are exceptional, occasioned by reason beyond control of the defendant, and grave injustice would be occasioned if the time was extended. Grave injustice would be occasioned if the time was not extended. Also, the learned counsel failed to state any ground for delay was in filing of the written statement in petition put forward before this court. Also, Salem versus so the Honorable Supreme Court held that there is no restriction in Order 8, Rule 10, that after expiry of 90 days further time cannot be granted. The court has wide power to make such order in relation to suit as it thinks fit. Clearly, therefore, the provision of Order 8, Rule 1, providing for proper limit, upper limit is 90 days to file the written statement as directory. Having said so, we wish to make it clear that order extending time to file written statement cannot be made in routine. The time
Okay,
can
okay,
be,
it's okay, okay,
my lord,
okay, it's okay.
my
All
lord.
right. You have any supporting judgment? I'll grant you time. You go and file written statement.
My lord.
Okay.
My lord,
Said all.
regarding
You have any
supporting,
supporting judgment?
regarding supporting judgment, my lord, in the ground, my lord, I have referred judgment, my lord, of Guwahati High Court. I will supply the copy, my lord.
Okay.
That is at page 7, my lord. Page 7. In the middle, my lord. For that the learned trial court failed to consider the words Order 8, Rule 1 CPC shall not be later than 90 days. Do not take away the power of the court to accept the written statement filed beyond time.
Where is the petition?
Further, the nature,
Petition
my lord,
rejected?
my lord,
Your petition which was rejected along with the written statement? Your petition?
my petition,
uh,
my petition, my lord, yes, okay.
which was rejected along with the
Yes,
written
my lord,
statement?
yes, my lord. My petition, my lord. Your lordship
You
got
pay
it
some
in
cost.
20, page 27. Yes, ma'am.
Will pay some cost.
Yes.
27.
My lord, page
How
26,
much you are willing
page
to pay?
27, page 27, my lord.
Okay, how much you're willing to pay? Cost?
My lord, cost.
Huh?
Cost, my lord, it is a family dispute, my lord, actually, within the family.
But
I'm
you have
leaving
to pay
to,
some cost.
I'm leaving to your lordship. my lord. Minimum cost, my lord.
No, I'm not asking for the written statement. I'm asking for the petition accompanying the written statement.
Accompanying
Which was
petition, my lord,
rejected.
petition 27, page 27,
Page 27.
27 and 27A.
See, only two paragraphs. You
My lord.
really shown any.
That is there, my lord.
Ground.
I do agree with your lordship. Because, my lord, here, this is the,
It's okay, it's okay.
my lord, it is the work
It's
done by
okay,
the
it's okay.
advocate, my lord.
Third learned counsel, Mr. M.A. Sheikh for the petitioner. Foreign Medhi. Foreign Medhi petitioners, Foreign Medhi.
Petitioners.
Niranjan Medhi, who have filed this application under Article 227 of the Constitution of India for setting aside the impugned order dated 4/6/2025 passed by the learned civil judge within bracket junior division bracket close number 2 Gwalpara in TS 163/2023, whereby the joint written statement of the petitioners was not accepted. Full stop. It is submitted on behalf of the petitioners that the petitioners may suffer irreparable loss if the written statements are not accepted. Full stop. This is a land dispute, and if the petitioners are not debarred from contesting this case, they will suffer from irreparable loss. Full stop. The petition which was rejected along with the written statement is marked as Annexure 6 of the petition, full stop. It is admitted that the petitioner had taken 3 adjournments in succession, 3 adjournments.
Yes.
3 adjournments in succession, full stop. However, it is submitted on behalf of the petitioners that the petitioners will not delay the matter any further, full stop. I have scrutinized the Annexure 6, and it cannot be denied that the petitioner was indeed vague, full stop. Petition was indeed vague. Except for a statement that the petitioners will suffer irreparable loss and injury if they will be deprived from submitting the written statement. The petitioner has also relied on a decision of this court in page 7.
My lord. Your lordship will turn to page 6, my lord. Page 6 mane, ground number 5. Guwahati High Court, my lord. Anand Reddy and Brothers versus Subhash Chandra AIR.
Page 4. Decision of this court in ground number 5.
Yes, my lord, ground number 5, case of R.N. Zadi and Brothers versus Subhash Chandra AIR
In the case of
2007
Oren
NOC.
Dadi and others versus Subhash Chandra, reported in AIR 2007 within bracket NOC, bracket close 2309, Guwahati.
And your lordship,
Post
other
of it
decision.
is further submitted that
Other decision is there 7, my lord, ground 7 and 8, my lord. Supreme Court decision.
It's not required because first I have already referred to Guwahati High Court
Obligement,
decision.
obligement.
Then again,
Okay.
I think Supreme Court judgment has to be referred initially, then Guwahati High Court judgment.
Purpose is to get relief, my lord. Nothing else.
It is further submitted that the learned trial court failed to consider that the words in order 8 rule 1 of the CPC shall not be later than 90 days do not take away the power of the court except written statements filed beyond time. The delay and laches cannot be ignored. However, for interest of justice, it appears that a opportunity may be accorded to the petitioners to contest the proceeding and submit the written statements. First of,
Lord,
I have also
written statement already submitted, my lord. This is to be accepted.
and to submit a written statement which submit a written statement and contest the proceedings.
Page 28 is the written
It is
statement.
further submitted that the written statement has already been submitted with the petition. And it is required to be accepted. Annexure 7 is the written statement which was submitted with the petition. Annexure 6, which was rejected by the learned trial court. For the interest of justice, this petition is allowed. The petitioners are directed to approach the trial court. This petition is allowed by setting aside the impugned order. Where is the impugned order?
Impugned order, page 43, my lord.
Impugned order dated page
4/6/2025. Page 43.
impugned order dated 4/6/2025.
Or 25, my lord, sorry.
In TS number 163 of 2023. Petition is allowed with cost of rupees 1,000.
Yes, madam. Much obliged. So, my lord, is it necessary that the trial court will accept the written statement?
I have already given the pass the order. Petition is allowed.
Obliged.
I'll correct the order.
Hello.
I'll correct the order.
Yes.
During
But
correction,
online-
I will insert everything that is necessary.
But
Nothing to worry
only
about.
online, my lord, if your lordship,
Yes, sir.
subject to your lordships, that written statement
We don't accept
submitted,
the written statement.
already
Yes,
submitted, may be accepted.
Written statement, accept the.
Already
the
submitted,
learned
may be
trial court to
accepted by
accept
the learned.
written statement. Within 1 week from today, or one
Lord, it is
month,
fixed on 19, on next day,
on the next date,
fixed,
on the next date fixed for, on the next date fixed.
my lord.
Before the appear before the learned trial court and file a written statement. Oh, no, and
My lord, only thing is this written statement already filed, may be
written
accepted.
statement to be accepted.
Much obliged, much obliged.
May please, your lordship.
Mm.
Your lordship, we have filed this revision petition, lordship,
Mm.
against the order dated 7/2/2025, lordship. Annexure 4, page 26, lordship. Your lordship, our opportunity to file the PW has been rejected, Lordship, by the trial court, Lordship.
Page 25, 3.
Page 26, Lordship.
This
May I
is
read
the order.
Order. May I read the
Yes.
dated 7/2/2025, both the sides are represented. Today, the case is fixed for evidence of PW's payment of cost. The engaged counsel for the plaintiff, White so-and-so, has prayed before the court to allow the plaintiff to submit revision petition as the plaintiff has been suffering from chronic kidney disease and prostatomegaly. A copy of medical documents is also enclosed with this petition. On going through the medical documents, it has been seen that medical certificate was issued on 21/2025, which is irrelevant as of today. Peruse the case record. On such perusal, it has been seen that by order dated 21/11/24, the plaintiff sought for leave to review the order passed by this court. However, since then, plaintiff has been continuously sought for adjournment for review of the order showing cause. On further perusal of the case record, it is also seen that prior to revision, the plaintiff had sought repeated number of adjournments to tender evidence of PWs. Considering all, the prayer of the plaintiff in petition number so-and-so is hereby rejected. The case shall proceed to its next stage, fixed on 13/3/25 for
Okay.
dependent evidence, Lordship. And still the case is at the stage of dependent evidence, Lordship. And on
What revision petition?
Lordship.
There,
Lordship, actually the petitioner as a plaintiff before the learned court below, Lordship, has prayed that he will file a revision petition against
what revision petition?
before the higher court, Lordship,
Before this court.
Lordship, which he has not filed, Lordship.
Hmm.
Because in earlier before this order also, Lordship, a cost was imposed upon the plaintiff, Lordship, as he could not file the PW's, Lordship. To silence that order, he has submitted that he will file a revision petition before the higher court, Lordship, but he has not filed. Yet he has also submitted the cause for not filing the revision petition because he was suffering from this chronic kidney disease and other disease, Lordship. It's because that prayer has not been taken into consideration by the court, Lordship. My only given is that, Lordship, I am the plaintiff in the title suit, Lordship. I will be given a chance to file my evidences because my lord, at this stage also, Lordship, the case is fixed up for DWs only, Lordship, which they have not filed yet, Lordship. It will not be.
Which is the earlier order?
Lordship. I have annexed all orders, Lordship. And look at here on the page 11, Lordship, first order, Lordship. Annexure 1. Dated 1/6/24, Lordship. May I read, Lordship?
Yes.
Today, the case is fixed for evidence of PW's record. Plaintiff has tendered certified copy of so-and-so, which is technically the case record. The engaged counsel for the plaintiff by petition number so-and-so is prayed before the court to adjourn the case for today as a talk of mutual solution are going on between both the parties. Our prayer is allowed. Next, 6/7/24 for evidence of PWs. And here, Lordship, 6/7/24, what happened? Today, the case is fixed for evidence of PWs. The engaged counsel for the plaintiff by so-and-so has prayed before the court to adjourn the case for today as a talk of mutual solution are going on between both the parties. Plaintiff has also stated that one criminal case bearing number so-and-so is going on between the parties, which was posted on 29/7/24 at additional session court. Further, the plaintiff has stated that prior to settlement of the criminal case, they are finding it difficult to settle this civil case. However, the engaged counsel for the defendant has verbally stated that defendant is not aware of the fact of amicable settlement with the plaintiff. Considering all, the prayer of the plaintiff is allowed with a cost of ₹1,000 to be paid to the defendant on a next date fix. And next date 1/8/24. Page 13. Today, the case is fixed for evidence of PWs, the engaged
Okay,
counts.
okay. That was allowed with 5,000 cost.
Uh, 1 plus 6, 7, 6,000.
And this is the last order,
Lot.
22/8/2024.
My prayer is that Lordship, I will be given a chance to find my PWs Lordship because only
This case is fixed for DWs or PWs?
DWs Lordship. Now,
Hey,
this-
where is the order rejecting the, you have already submitted your evidence or you have not submitted?
Not
your
submitted,
evidence?
not-
Where is the order rejecting plaintiff's evidence?
this is
That is the main order.
7 to Lordship.
Hmm.
Considering all the page 27
Hmm.
is
Page
hereby
27.
Lordship. Considering all the prayer of the plaintiff in petition number is hereby rejected, the case shall proceed to its next stage. Lordship.
Next stage,
DW Lordship.
DW.
And now the case is 13-3, it was fixed.
So
for
next stage is understood as DW.
DW. Lordship, I have recent order, Lordship, page 35,
Hmm.
31/7/25 order, and next date is fixed on 25/9, Lordship, for defendant evidence cost.
13/3/2025, where is 13? Oh,
Lordship.
okay.
Annexure 5, page
Okay, it's okay, okay,
Lordship.
it's okay.
I will pay the cost, Lordship.
5,000. The cost imposed was 5,000.
Total 6, Lordship.
6,000.
Because if there's other costs also, Lordship may not mention the amount, Lordship. Whatever the cost was, I pay.
Our learned counsel, Mr.
Our coupon, Lordship.
Arkupon,
Lordship.
for the petitioner. Rajiv Ahmed,
Lordship.
who has filed his application under Article 227 of the Constitution of India. As is agreed by the order dated 7/2/2025 passed by the learned civil judge junior division number 2 Gulagar in connection with title suit number 10 of 2022. It is averred that the plaintiff has been debarred from adducing plaintiff's evidence. Full stop. It is submitted that the plaintiff will suffer irreparable loss if he is not allowed to adduce evidence. Full stop. The plaintiff has taken adjournments and the learned trial court has passed orders dated 1/6/2024, 6/7/2024, 1/8/2024, 22/8/2024, allowing the adjournments, and the case was thereafter fixed for plaintiff's evidence. However, on 7/2/2025, the learned trial court rejected the plaintiff's submission relating to his delay owing to chronic kidney disease and PROSTATOMEGALY. And the case was then fixed for defendant's evidence. Full stop. The costs were imposed on the plaintiff when the plaintiff was granted adjournments on 6/7/2024 as well as on 1/8/2024, and the plaintiff was contemplating to prefer revision against the cost imposed upon him. Full stop. However, owing to his ailment, the plaintiff was unable to prefer the revision, and the plaintiff approached the trial court to review the order. But the trial court declined to review the order, and this case has proceeded to the next stage, that is for defense evidence, full stop. It is submitted that the entire title suit would be rendered infructuous if the plaintiff is not allowed to adduce evidence, full stop. It appears that an opportunity may be accorded to the plaintiff to adduce plaintiff's evidence. The plaintiff is also willing to deposit the cost imposed upon him. Full stop. For the interest of justice, comma, the order dated 7/2/2025. This one you are trying to be is set aside. The plaintiff is directed to, the plaintiff is allowed to adduce plaintiff's evidence under the condition that the plaintiff would not delay in adducing evidence and procrastinate the case, full stop. The cost imposed upon the plaintiff is to be deposited before is to be deposited as per order passed by the learned trial judge. In terms of the above observation, this application stands disposed of.
Obliged.
This petition stands disposed of. You wanna see it?
Lordship, this petition arises against the impugned order dated 9/12/2024 by the Honorable Member MSCT number 3 at Kamrup. The respondents had filed a claim application of with regard to an accident that occurred on 9/3/2011. And after a decade, they have filed basically, they have filed a case, MSC case. So after a decade, they have filed this case. So as per the section 166 of the MV Act, although a limitation period was not given, however, the Supreme Court in Purohit and Company versus Khatun B had actually rejected a claim stating that it was a dead claim because no reason had been provided for such delay. And the Honorable Guwahati High Court also has in a judgment stated that any delay which has not been explained, an unreasonable delay, the claim cannot be said to be a live and surviving claim. So that is why we pray this honorable court to admit the case and to put a stay order on the case, the MSC case 382 at the Kamrup MSCT number 3.
Case is proceeding at which stage?
The evidence has not been filed by the claimants. We have already given the written statement.
There's one judgment of the Supreme Court.
Yes.
That, if the accident information report is registered and if a criminal case is registered, then there is no period of limitation.
Yes, but the Supreme Court in Khatun B, it is a 2017 case. They have stated that an unreasonable delay, which has not been explained, the respondents, the claimants have to explain their delay. If they cannot explain their delay, then it will be.
Have you annexed the claim petition?
Yes. The claim petition is annexed at page 26, annexure 3.
Page 26?
Page 26.
No.
Claim petition, page 26, annexure 3.
No. Page 26, okay.
This is the claim.
This is the notice we have.
Claim petition. Next is the claim petition, page 27. Page 27, 28.
Yes. 9/3/2011, and the incident occurred after, and the claim petition was filed on
Petition filed. 2020, my lord.
2020.
20.
We can get the date in the affidavit, verification. Filed in the year 2020. Yes, of course, there's no reason.
Lordship, the Guwahati High Court also passed a judgment in a similar case. It has been annexed as Annexure 5, page 37.
Page?
37.
And this was after service of notice.
Lordship, yes.
This order was passed after service of notice.
Yes.
We'll issue notice, Judge. We'll stay the order later.
Yes.
We'll issue notice.
Obliged.
There's no vacation of stay order or something else of that sort.
Nothing.
So we'll issue notice. We'll stay later.
Kindly permit stay.
Do we, shall we call for the, we can admit it, we'll admit it. Shall we call for the trial court records? Not
Yes,
required.
yes, yes,
Required?
yes.
Okay. Scan copies because proceeding is going on. Learned
They
transfer.
may kindly be passed. The proceedings may kindly be stayed.
We'll pass an order later relating to stay.
Stay order.
Yes, we'll admit it. We'll admit it.
But in similar other cases, stay has been passed in Guwahati High Court. Yes.
But in this case, it was not passed. Otherwise, at end of the order, we will get the order for vacating the stay order.
That is the judgment. But
Hmm.
initially stay order was given.
But there's not, in the judgment, it's not mentioned, stay granted.
The
earlier has been
judgment,
vacated.
it is the final judgment they have
Automatic-
given.
Okay, automatically it will
Yes,
get
first
vacated.
order was stay order and admission.
Lordship, the Guwahati High Court also passed a similar order for your perusal.
It is not covered by the amended act.
Lordship,
That trial court has correctly held. This is not covered by the amended act.
That is there.
Yes.
That is there, my lord,
This was before the amendment.
before the amendment. And in Purohit and Company versus Khatun B, Honorable Supreme Court passed the judgment in 2017. Whereas the amendment has come in 2019, effective from 1st of April 2022. But Honorable Supreme Court said, despite the fact that there is no limitation, but there must be a reasonability of filing a case because the other party is prejudiced by delay in filing. In motor vehicles rules, my lord, Central Motor Vehicle Rules prescribes that all insurance companies will be keeping their record, preserving their underwriting records for 5 years. But somebody is coming after a decade or 18, in another case, we have given, this Honorable High Court has given an order where the case has been filed after 18 years. So Honorable Supreme Court has observed, despite the fact that there is no limitation, the case is a stale case, it is a dead case, so it has to be dismissed. And if the party fails to justify by sufficient cause. This Honorable Guwahati High Court, in another case, CRPIO 188,
Annexure 5.
Annexure 5, Guwahati High Court directed the tribunal that you ask the complainant, claimant, to explain. If they fail, dismiss it. Accordingly, the tribunal has given them opportunity to explain. They have failed and the case has been dismissed. That is also annexed here.
Annexure 6.
Annexure 6, page 48. The case, MSCP case has been dismissed because they failed to explain. And this is a analogous case to that. The order we have given. So this is a case filed after decade, but not in other Gwalpada, but this is in Kamrup. The thing is, things are coming from Pandora's box. That door has kept open because the limitation was not there. And the legislative intent was that party should be given opportunity, but it has been misused. Then again, limitation has been imposed in 2019 amendment.
Yes, So you have come against the order dated
9/12/24
passed by the
MSc,
MSCT,
yes.
rejecting your application.
as a preliminary objection, yes.
Good order has been passed. Very recent and good order has been passed, but I am not inclined to grant stay. Now, I'll call for the records.
But the case will proceed that way.
Let it proceed, we'll grant stay later. I'll admit it.
Stay, I think stay is better because the case will stay. If the merit permits, then it will be released later on. After hearing.
I think case has not progressed that far. You have to file WS.
WS we have filed.
You have filed.
We have
So
filed.
they will reduce evidence.
They are,
On next date, we'll take up the matter for stay. I'll record it. Learned Counsel, Mr.
A Das.
A. Das and Learned.
A N Das. His name is not reflected in the cause list, although his name is there in the column.
Okay, your name?
A N Das.
I'll reflect both, I'll record your names. A and Das are present for the petitioner. It is submitted that after a decade, a claim petition has been filed relating to an accident which occurred on 9/3/2011. Full stop. The veracity of this case is under cloud, and thereby the proceedings of MSC case number 382/2020 may be stayed as, the petitioner has filed, as the petitioner, insurance company has filed an application under Article 227 of the Constitution of India, therewith Section 151 of the CPC, challenging the order dated 9/12/2024 passed by the London MSCT number 3 or Kamrup Metro, full stop. The objection against the MSC case number 380 of 2020 was rejected by the learned tribunal. High order dated 9/12/2024. Call for the scanned copies of the trial court records. Issue notice to the respondents. The prayer for interim stay may be considered after receipt of the trial court records or on the next date fixed. On the next date of listing.
As you please.
On the next date of listing. List, issue notice to the respondents returnable within 4 weeks. List accordingly.
Much obliged.
Much.
May I please, my lord? My lord, this is an application, my lord, under 227, challenging an order passed by the court below, my lord, by which the amendment under Order 6 Rule 17 was allowed. On the, my lord, the respondents, my lord, as in plaintiff, my lord, they have filed a suit challenging the order of eviction.
Amendment was allowed.
Amendment was allowed. Against that, my lord, we have come. And our basic plea is that, my lord, that amendment has completely changed the nature of the suit.
Will issue notice?
My lord, I am praying for a stay, my lord, because if my lord goes through the pleadings, prima facie, my lord, the entire nature of the suit has been changed. A different date of cause of action,
Okay.
my lord, has been taken into consideration. I would like to satisfy my lord, because the matter is fixed for framing of
Evidence.
issues, my lord. Because after issues, my lord, the evidence will start. So that is my prayer, my lord. If I take, my lord, to page 49. Page 49 is the, my lord, prayer, it is the part of the plaint, my lord, filed by the respondents. If my lord take paragraph 20, the prayer of the, if I may read, my lord, paragraph 20,
Yes.
that the plaintiffs state that though the plaintiffs are the owner of their respective schedules land, which are distinct and different, but they have been illegally evicted by the defendants, particularly defendant number 1, 2, 3. 1, 2, 3 are, my lord, railway authorities. On the same day, by virtue of notice dated 26/10/2018, under Rule 18(2) of the Assam Land and Revenue Regulation, the plaintiffs have common cause of action against the defendant, and as such, the instant suit has been filed. So, my lord, this suit was filed after the eviction. They were evicted from a railway land, my lord, following due process of law under section 18(2). Now, my lord, will take paragraph 22, wherein the cause of date for cause of action is mentioned. The cause of action for the suit arose on 14/8/2006 and 21/1/2009, when the Honorable Court of Munsiff, by judgment and decree, held that the scheduled land is not a reserved land for railway, rather it is a patta land, comma, on 26/10/18, when the defendant number 3 issued notice of eviction under Rule 18(2) of the Land Revenue Regulation Act, on 29/10/18, when the plaintiff have been evicted by the defendants, particularly the defendant number 1, 2, and 3. So, my lord, this was the prayer in the suit. And if my lord take the prayer also at page 50, my lord will see at clause B, it is mentioned a decree that the land described in schedule A to G not been a railway land or the state land, and the notice dated 26/10/18 issued by is illegal. So, my lord, this was the prayer in the main suit.
Prayer, which prayer? Oh,
Prayer
number
clause
B.
B, my lord. Prayer clause B.
Okay.
Decree praying for setting aside the notice of eviction dated 26/10/18. Now, my lord. Now, my lord, I will take to page 75. Page 75 is the miscase, my lord, filed by them for praying for injunction. And if I take, my lord, to the prayer reads as follows, that it is therefore prayed that the honorably graciously plead to admit this petition, further be pleased to grant temporary injunction restraining opposite party defendant and main agents from making allotment or settlement of land on schedule A to Z of the application in any other organization, and further pleased to restrain the defendant opposite party from proceeding with any construction or development work over the scheduled land. So what I am trying to point out, my lord, is that the eviction had already taken place, and it is only after the eviction the suit was filed. Now, my lord, coming to the amendment sought by the respondents here, my lord, page 99 is the application under Order 6, Rule 17, read with Section 151 of the Code of Civil Procedure for amendment of the plaint. Here, my lord, will take page 103. Paragraph 7. My lord, the statement is that the plaintiff state that after the filing of the suit, my lord has got it, page 103, paragraph 7, that the plaintiff state that after filing of the suit, the present plaintiff, with the knowledge and acquiescence of defendant number 1 to 6, have again come into occupation and possession of their respective scheduled land on 16/1/2021. Now, my lord, the persons who were lawfully evicted and challenging that eviction order, a suit has been filed. Now, my lord, how can those same person, my lord, take a repossession of the land and make this as a cause of action? Now, my lord, the prayer, my lord, is that they are stating that on 16/1/2021,
Plain file, that
Yeah.
earlier plain,
my lord,
earlier plain, when was the plain file? Earlier,
2018,
2018.
2018, they were evicted. Now, my lord, they are saying that
No, that plain, when was the plain file?
2018, my lord,
Same.
same schedule of.
On the same year when they were evicted.
Yes, yes, my lord. Same schedule of land, schedule A to Z. Now they are saying they have re-entered schedule A to Z on 16/1/2021. Now, my lord, if I may read further, it is pertinent to mention herein that as stated above, the land described in schedule C, D, and F, whereupon houses and structures is existing, the plaintiff number 3, 4, and 6 have been occupying and possessing the same by letting out different tenants. The plaintiff state that in view of the aforesaid change circumstances and amendments of the plaintiff is required by incorporating the new paragraph after paragraph 18, which would be numbered as 18A. The plaintiff further state that in the counterclaim filed by the defendant number 4, 5, and 6, they have sought for recovery of possession of the scheduled land as it is within the knowledge of the defendant slash counterclaimer number 4, 5, and 6 that before filing the written statement, the plaintiffs have again entered into the said schedule described in schedule A to Z of the plaint. Now, my lord, the plaintiff states that the new paragraph wants to be added as follows. Now, my lord, we'll see what is the parameter. I am trying to satisfy, my lord, prima facie, without their version, whether this amendment can be allowed. Paragraph 18A, that the plaintiff state that after institution of the present suit, the present plaintiffs have again re-entered. This is the new amendment which they sought to make. Re-entering on a land which they were evicted from and which they have already filed a suit. That was sub judice, my lord. Matter was sub judice, and again, now they have filed this prayer for amendment stating that this paragraph should be added.
Because you did not include in your written statement that
Hello?
they have re-entered. Because you did not include in your written statement that they have re-entered.
Till that time, they have not re-entered, my lord. This is their own version and own story. My humble submission is, my lord, when a person has been lawfully evicted and they have challenged that eviction process by way of filing a suit, only procedure is to wait for the outcome of the suit and to give evidence and lead evidence into that respect, my lord. Now, subsequently, whether a person can forcefully on his own re-enter the possession and make this plea that, my lord, they have re-entered into the possession of the land from they were already evicted and, my lord, unilaterally change the entire cause of action. Now, my lord, I will just read this paragraph, my lord, that the plaintiff state that after the institution of the present suit, the plaintiff have again re-entered and or take possession of their respective land as described in schedule A to Z on 16/1/21. Now, my lord, the very date itself shows that it's a subsequent cause of action, even if any.
Yes.
It's a subsequent, well, prima facie, it is revealed that they are saying that they have re-entered into land on 16/1/21. Therefore, it's a different cause of action altogether. With the knowledge and acquiescence of different 1 to 6, the plaintiff state that out of the aforesaid scheduled land described in schedule A to Z, there were houses, structures over the land described in schedule CDF, which belong to plaintiff 3, 4, and 5. The plaintiff states that after re-entering of the said scheduled land, the plaintiff number 3, 4, 5 have let out their premises to different tenants for different business purposes. Now, my lord, we'll take paragraph 9. In paragraph 9, they are seeking for amendment by saying that under the aforesaid circumstances, the plaintiffs are compelled to file the present suit for honorable court for declaration of right, title, and interest and for confirmation of possession. Now, my lord, initially when the prayer was made, that was not made for confirmation of possession. If my lord take the prayer portion again, of the plaint, my lord, paragraphs, page 50. That was praying for a decree, my lord, stating that defendants have no right to evict the plaintiff from the scheduled land. Now, my lord, they are saying that since they have re-entered the land, the prayer, my lord, they have changed from declaration of right, title, and interest to confirmation. Page 50 of the plaint, my lord, that is the prayer of the plaint. Page 50, clause C. Prayer is decree declaring that the defendants have no right to evict the plaintiffs from the land as described. Therefore, they are challenging the order of eviction. Now they are asking for confirmation of possession. This is prima facie illegal. That matter is sub judice. That cannot change. Allowing such an amendment would be illegal if I would rather humbly submit. Because they are evicted following a due process. They have challenged it in a suit.
This is prayer C, no?
Prayer C,
Which is contradictory to the new prayer.
contradictory to the new prayer.
Okay.
And my lord, these points we have already challenged. My lord, when we filed our written objection at page 110, paragraph 11. Paragraph 11, my lord, we have categorically taken the plea that paragraph 11, page 115, my lord. Page 1110 is the written objection. The operative portion is page 115. That the statements made in paragraph 7 of the instant application are false, baseless, and misleading, vague, lacks material particulars, and the answering defendant do not admit the same. It is specifically denied that after the filing of the suit, the present plaintiff, with the knowledge and acquiescence of the defendant number 1 to 6, have again came into occupation and possession of their respective scheduled land on 16/1/21. The answering defendants state that it is an admitted case of the plaintiff that they were evicted from the alleged land in the village North Jalukbari, Mausa Jalukbari, pursuant to notice dated 26/10/2018 issued by defendant number 3 under Rule 18(2) of the settlement rules frame under Assam Land and Regulation Act 86. And as such, the prayer was made for recovery of possession of the alleged land alleging illegal disposition. However, by the instant application, a new fact and a new cause of action has been tried to introduce that the plaintiff, with the knowledge and acquiescence of the defendant number 1 to 6, have re-entered the said scheduled land on 16/1/21. The plaintiff were evicted by the competent revenue authority under the provisions of the concerned statute, and once evicted, there is no provision to re-enter into the encroached land. Therefore, the alleged re-entry is an illegal and unauthorized act, and that too when the matter is sub judice before the court. Hence, the statement of re-entry itself amounts to taking the law into the own hands of the plaintiffs, thereby disregarding the process of law initiated by the plaintiff themselves. So, my lord, this is the basic.
Okay, okay. All right.
My lord. My lord, here I am.
You are for railways,
My lord, I am for railways, my lord.
sending council,
Yes, Central Government Council, my lord. Central Government spending.
CGC.
CGC.
Third learned CGC, Mr. H. Gupta for UI or for all the applicants,
All the applicants, my lord.
1, 2, 3.
Yes.
For the petitioners, full stop. The petitioners are agreed by the, where is the order? Am I of amendment?
Page 121, my lord. Order dated 11/12/2024. Page 121, Annex 7.
By the order dated
11/12/24.
11/12/2024, passed by the learned civil judge number 2, Kamrup Metro, in connection with Mijay case number 856 of 2024, in connection with TS number 560 of 2018, full stop. It is submitted that wide order dated 11/12/2024, allowing amendment under order Rule 17, read with section 151 CPC. The entire cause of action or the entire nature of the suit has been changed, as the cause of action has also been changed. Full stop. The title suit was filed after the eviction of the respondents. All the respondents.
Private respondents, my lord. 1 to, my lord,
After
1
the
to 12.
eviction of respondent number 1
To 12.
to 12, on 20/12/2018, when the plaint was filed, full stop. But the new cause of action arose, according to the plaintiffs, arose on 16/1/2021, full stop. the new cause of action arose during the pendency of the title suit, which is illegal. Full stop. Unilaterally, the entire cause of action along with the nature of the suit has been changed, as the earlier prayer was prayer number C, which is the prayer number C?
Page
Was
15.
for a decree declaring the defendants declaring that the defendants stroke petitioners have no right to evict the plaintiffs, whereas on the contrary, after the amendment, the new prayer is whether the defendants have the right to dispossess the plaintiffs after dispossess the plaintiffs after re-entering of the plaintiffs into the suit land. Full stop. It appears that stay may be granted in connection with title suit number 560 of 2018. Thereby, further proceedings of TS number 560 of 2018 is stayed till the next date of listing. Issue notice to the respondents returnable within 4 weeks. List accordingly.
My lord, one prayer, my lord, respondent number 14 and 15. My lord, Deputy Commissioner Solitpur, that is wrongly, my lord, that will be Kamrup, my lord. I may be allowed to correct by hand. my lord.
Then I cannot pass an order of stay today. Later. You correct it, then we'll pass an order. After correction. You correct it
My lord,
later.
the
No.
private respondent, sir, my lord, this is regarding, my lord, the Deputy Commissioner only, my lord. Otherwise, State of Revenue Department, it is correct. State of Assam Revenue is, because it is a, my lord, challenge against the order.
No,
Whatever,
no, see.
my lord, the party is there in the suit.
Railway is railway and the land relating to railway comes under the administration of also state.
No, lord, we have only made parties in the
No.
suit. Whoever,
Correct it, you correct it. I'll pass an order after 2-3 days. You come before me after 2-3 days. You
I will
correct it.
correct it now itself, my lord.
No, you correct it and then we'll pass an order.
Lord, we'll take it tomorrow in that case.
Yes,
Tomorrow.
tomorrow. Yes, maybe
No, no.
tomorrow. Finally tomorrow. Day after tomorrow, not
No, no.
tomorrow, day after tomorrow. Yes, day after tomorrow. Please this matter day after tomorrow. ए बाकी वो order वो नहीं चाहिए. वो टैप টাইপ করবো না লাগে তাকে নিয়ে লিখি বাকি টাইপ না করবো এইটো রাশি হয়ে যায় কালি যদি পুহি যদি রাখে মই করে দিম
Made this a motion. Your lordship, the petitioner here is the sub-distributor of one MS Jagriti, sub-distributor of selling Honda motorcycles. So after that distributorship was entered in the year 2014 itself. And your lordship knows the distributorship includes selling the showroom as well as the service center. So the petitioner here had invested huge amount of money and payment of salary, construction of the showroom and the service center. So from 2014, the sub-distributor was working under the MS Jagriti. Jagriti is a distributor. So till 2024, it went on fine, but suddenly the dealer code was blocked by the distributor in December 2020. The dealer code.
Okay.
If the dealer code is blocked, then I cannot sell the motorcycles.
Yeah.
So it was blocked in December 2024 suddenly. Then I inquired what was the reason. The answer was that it is the company which has blocked it, not the distributor. So accordingly, I filed a suit wherein the distributor has been arrayed as defendant number 1 and 2. And the company is defendant number 3 and 4. Along with the suit, I had also filed the injunction petition under Order 39 Rule 1. Your lordship, in the objection of the 3 and 4, that is the company, which according to defendant 1 and 2, which is a distributor, is according to him, the company has blocked it. Whereas the stand of the company, who is defendant number 3 and 4, the lordship will find that in the injunction order itself. That is, starts at page 75. And the relevant part, your lordship, 78. Lordship, 78. The written objection of opposite party 3 and 4. That is the company. Lordship has seen that. 78.
Written objection, yes.
3 and 4 is the company. So according to the distributor, it is a company which has blocked it. Where is the stand of the company is that at the last line, if your lordship says para 11, para 11 last line, blocking of the petitioner was done by opposite number 1. So they are saying it is the distributor who has done that, not them. And the answering opposite party 3 and 4 have no role. Moreover, the petitioner has not made any agreement with the answering opposite parties, and hence the dispute is purely between the petitioner and opposite party number 1. So they are saying it's a dispute between the sub-distributor and distributor. Secondly, in para 12, it is therefore prayed that taking into account the present written objection, and after hearing the parties, be pleased to delete the opposite number 3 and 4 from the array of parties for the interest of justice. That was the stand. And the injunction was not granted on the first day, but after hearing all the parties, after considering all the material facts, and also considering the 3 golden principles, the trial court was pleased to grant an injunction in my favor. They considered duly the balance of convenience, all the 3 golden principles.
Then it was vacated.
No, vacated in the sense that appeal was not preferred by the distributor. After taking this stand, the company preferred the appeal. Whereas their stand was that they should not party to this suit itself, they should not be part. And on the along with the appeal, another miscase was filed for a stay of that injunction order. While granting the stay, your lordship will find that at page 109, that is a typed copy. Because the trial court, after due deliberation, has given the injunction order. And your lordship knows that injunction order should not be interfered with just because the appellate court has a better view or better opinion. They cannot substitute the view unless there is perversity. And that perversity has to be recorded, your lordship. But here, if your lordship sees the second para, I am of the considered opinion that there is a prima facie ground to stay of the operation of the order dated 6/6 passed in Mise until the final. There is no reason recorded why if there is any perversity. It's only his opinion that there should be stay, and they had taken away the right that has been granted in my favor. It is only to protect my incursion of the right of that has happened. Only simpliciter stay without any reason. In that regard, because the trial court has considered the irreparable loss that would be happening to me, because the business has been conducted all throughout. There is an injury that has been happening on daily basis. After considering all this aspect, the injunction was granted, but without recording any reason, if there is any perversity, whether if there's the 3 golden principles were considered or not considered, nothing, just simpliciter stay. Which the lordship knows, and the Honorable Supreme Court has time and again that we should be, the appellate court should be cautious in interfering in the injunction order if there is application of mine and all the 3 principles has been satisfied. Lordship. And this is the order on the first day, before issuing notice, not been heard. The petition, the plaintiff in the suit, who is the now opposite party here, he has not been heard also.
It's okay.
And your lordship will see just one paragraph, 11, 13 and
On
14.
8/8/2025, 1 month only.
1 month, but this miscase has been disposed of. The misj case, the stay application has been disposed of. Now the appeal will be pending. Your lordship knows the appeal will now take how long? In the meantime, I'm not being able to operate the business. If your lordship says just paragraph 13 and 14,
This appeal was preferred by whom?
by the company, who were opposite party 3 and 4. Their stand before the trial court was that they should be deleted from the.
No, no, no. I cannot, what is your prayer now? At this juncture, I will have to hear both sides.
Yes, but this order was passed.
Now what is your prayer?
I'm only asking for stay of this order.
No, no.
Yeah, if a lordship see
No,
paragraph
no, no,
13 and
no.
14.
Because the company has preferred. They have been deleted. We will hear.
No, they have not been deleted. Their stand was this is a dispute.
I understand very well. I know you will incur some loss, but we'll have to hear the other side.
But if your lordship sees just one paragraph, paragraph 13 and 14, the Supreme Court order, if I may just say, because the.
No, we will hear it. When we will take up a final hearing, we'll go through this.
Only prayer is your lordship see, this.
Very short date, very short date.
Yes,
First day after puja.
Yes, but the trial court had passed an order after hearing both sides. It's not was on the first day. It was not a.
I understand, but now they have preferred the appeal, no?
They have prepared the appeal.
So
That
they-
appeal
they
is pending.
fighting- No, no.
But the
when
stay was granted.
Company doesn't want to, when the company doesn't want him to proceed with the business, let's call the.
But the stand of the
company.
company was, your lordship, there's a dispute.
The court will not go jump in between the company and the.
If your lordship sees the stand of the company, just for my satisfaction, one more time, page 78.
No, I have gone through page 78, yes.
Yes, their stand
And,
was,
But
this-
now they have preferred the appeal, no?
that appeal is pending. That's not problem, your
Yes, you
lordship.
see.
But the
No,
stay
no,
was granted
this
without
will-
hearing me, just simply
So
sit a
this will-
stay
this
without
will be
recording
a-
reason.
This will be a very absurd order. The company has preferred the appeal and why? should
But
the
there
appeal
was
be
no
stayed?
reason recorded, your lordship.
I understand, but again,
Because that order, what that order,
pass an order after hearing, then it's okay, but without hearing. the
but if your
company-
lordship sees the main injunction order, page 75,
I have seen, I have understood
yes,
it.
the prima facie balance of payment, it was discussed in detail.
I've understood. it. Now you cannot go into the details of. We
No,
have
I'm
to
not-
see the interest of the parties. The company has preferred the appeal.
Yes.
So we will issue notice, very short date.
Only thing then your lordship may see paragraph 13 and 14 of the Supreme Court judgment that,
We'll decide it.
yes, yes, lordship will
Then
decided
we'll
only
decide.
that order if your lordship may
But
see.
this is a final order. No, we'll decide it. When we'll decide it, we'll take this into consideration. Definitely we'll take this into consideration.
But your lordship
No,
says
there you see,
there's a salary of the employees, they all are put to stagnant because of this order.
who is asking him to run the company? That sub.
But the stand of the company was,
Sub-dealership, the company doesn't want him to run the sub-dealership.
the company
They
stand was
preferred
not
the
that.
appeal.
Company stand was not that.
No,
Company
but
stand was,
now they have preferred the appeal.
yes, they prefer that appeal is pending, your lordship. They may hear the appeal within a month then.
He cannot. When the company doesn't want him, why should we
Your
impose
lordship's-
pressure upon the company?
It was a
We'll-
spec-
a very short date. next
Yes,
time
only
we'll-
thing, your lordship, the company stand was, this is, we are not privy to the contract between the distributor and the sub-distributor. So we are not party to the dispute. It is a purely dispute between the sub-distributor and the distributor. Distributor has not preferred an appeal. Your lordship sees the 78, your lordship
No,
says-
no.
but the distributor has not preferred an appeal. It's a company has preferred an appeal, that appeal is pending on the injunction. They have preferred an appeal on the injunction order, that appeal will be heard. But the stay was granted, is an ex parte stay without recording any reason.
No, you
I
see,
want to-
earlier the
point.
dispute was between the distributor and the sub-distributor.
Yes.
Now the dispute is between the company, the distributor and the sub-distributor. Why will the company
all
prefer
along,
an appeal?
in the objection also, in the
No,
objection
no.
also, lordship, the
Not at all
company,
convinced, not at all convinced.
the company,
I'll issue notice. I'm really not convinced.
or your
I'm
lordship may say
sorry.
the appeal is pending. The appeal is pending.
This will defer it to the next date for motion.
Or your lordship may say the appeal may be heard within a period of 1 month. Because of the stay. 1 month or 2 months.
No, you see, I'll list it for another date. I'm not convinced.
No, if your lordship is not passing any interim order, then your lordship may dispose of this petition with a direction, will not interfere with the stay order and with a direction to hear the appeal within a period of 1 month. Because
No,
they,
no, that, how can I?
because the appeal is on the injunction. 1 month or 2 months, whatever, otherwise if the appeal is prolonged.
I don't know, in a civil case or in a criminal case, I have forgotten. Supreme Court has passed an order not to give directions to dispose of cases within certain period of time. But I have forgotten whether it's a civil case or criminal case.
Preferably, they are not bound by it obviously, but preferably. Otherwise, if there is no stay, if the appeal prolongs,
You see, you can convince next week. Next week is a motion we give. You can convince, not me, maybe some other bench next week. Next week is fixed for motion. Only motion matters. I'm not convinced.
because if your lordship sees the situation,
Maybe after hearing both sides, I may be convinced, but.
because their specific stand, they had not objected to the injunction also, the company. Their stand was, it is the dispute between them. We are not privy to this contract of distributorship and sub-distributor between the distributor and the sub-distributor. So we are not a party. Our name should be deleted. And it is not who we are blocked. It is a distributor who has blocked. After that has been
I
reported.
have understood your
Yes.
stance. I've
So, and the
clearly
distributor
understood
has
your
not preferred
stance.
an appeal, your lordship. It is a company now which.
I have understood your stance. Then.
But thing is, your lordship.
On Monday, on Tuesday? On Tuesday maybe? Fix for motion. Otherwise, I'll fix for SR, service report.
Otherwise, under 3A, direction may be given to dispose of within 30 days. Because it is an appeal against the injunction.
Injunction, yes, correct. Within 30
That's
days.
it. That may be done.
Yes. 3A, no?
3A.
Yes. You were right. Then I'll dispose it altogether. That is without notice.
Yes, but here also.
They have, both parties are appearing there.
No, in this case, the order was passed without notice. This stay was passed without notice.
Without
Yes,
notice?
now, yes, this was without notice on the first day. This was, they have not heard us while passing this.
Page 78.
No, 79 was
109.
109, yes.
That was passed without notice.
Yes.
Okay, then I can pass an order to dispose of within.
Yes. $106 is the main appeal order.
But this was disposed of.
This is disposal. I am asking the main appeal to be heard within a period of.
Main appeal.
Yes,
Which one?
they have preferred an appeal against an injunction order, against the injunction granted in my favor in the trial court. So along with that appeal, they have filed a Ms. J case for stay. So this stay has been, this Ms. J case has been stayed.
Or disposed of by.
Disposed of within the same day. So now I have.
Appeal against the injunction.
Appeal against it. So I am now dependent on the injunction. That injunction will take some, that appeal will take some time. I cannot contest this case also now, the Ms. J case.
You cannot contest, yes. Miss Appeal, Ms. J case, impugned order dated Ms. J case. Passed in Ms. J case number 48, 2000.
48 of 2005. And the Ms. Appeal is 5 of 2005. 2025.
Ms. Appeal is 5 of. Have you annexed a copy of the Ms. Appeal?
Yes. No, yes. That is page is 84. Annexure 7. And the Ms. J case is also 97.
No, see, this is under order 43 rule 1R. Is there any
Equivalent, no, but the principle
No, how can I borrow the principle of 39A to order?
Injunction, this is against the injunction only. But this appeal is against the injunction. If your lordship sees appeal from orders, order 43, an order under rule 1, 2,
No,
Group
no,
four?
this won't work.
subclause R.
This won't work. Let us list this matter next Tuesday. Otherwise, I can issue notice or I will list this matter next Tuesday.
Next Tuesday.
Next Tuesday. List this matter on Tuesday, 23rd September.
Oblate.
Please, your lordship.
Hmm.
Lordship, this instant transfer petition has been filed for transferring the TSM case number 172, 2024 from the Court of Learned District Judge Jorhat to Learned Principal Judge Family Court Guwahati, your lordship. I am the wife, your lordship. I am a resident of Shillong, your lordship. If we go to the petition of the petitioner, he is also a resident of Shillong, your lordship. But for his work purpose, he resides in Jorhat, your lordship.
Where do you want it transferred?
Guwahati, your lordship.
From?
From Jorhat. I am a resident of Shillong, your lordship. It's 370 kilometers, your lordship. Not possible for me. The case is fixed for.
Your husband?
Yeah, I'm the wife, your lordship.
You are
I
the
do not
wife.
have any job. The matter may be stayed for now, your
You are a resident of Guwahati,
No, I'm a resident of Shillong, your lordship.
Shillong.
Shillong, your lordship. He is also a resident of Shillong. Our marriage was solemnized in Shillong, your lordship. Our marriage was solemnized on 7/5/2023 in Jail Road, Puja Mandap, Shillong, your lordship. We resided there for a few months, but for his work purpose, we came to Jorhat and then we carried on our married life there. However, lordship, the cause of action also arose in Shillong in 1/8/2024, as stated in his petition.
Well,
Lordship, this matter is not fit for mediation.
not
my lord,
for mediation.
because we are challenging policy as well as driving
You are
license.
the insurer?
Yes, my lord.
Okay. Learned counsel, Miss
L. Sharma.
Miss
L. Sharma.
L. Sharma is present for the insurer and has submitted that there is no element of settlement in this case, and this case may not be referred for mediation. Is this matter after puja vacation? Obviously. Item 30.
May it please your lordship.
Yes.
Lordship, this is not a fit case for referring to mediation because all the family members are in.
Won't.
I am appearing for respondent number 2.
Maybe they want mediation, maybe you do not want.
No, they also don't want.
Do not want, okay.
And lordship, only thing in the appeal, lordship,
Respondent number 1 already died.
lordship will, by order dated 23/3/22, Mr. Patgiri had informed us the respondent number 1 had died. So we said we'll take instruction. Lordship, 2 and 3 are the legal heirs of respondent number 1. One is husband and one is son. So lordship will record that.
Will strike off?
No,
Not strike off, lordship.
Legal heirs are already there.
Already there.
already there.
But lordship will
So
pass
will
that.
strike off the respondent number 1 or not?
Yes,
required?
yes,
No.
yes.
Okay. Can struck off.
Yes.
Can be struck off.
Lordship will mention that 2 and 3 are already the
Ah,
legal heirs.
okay. Learned counsel Ms. Adi Mujumdar is present for the insurer, and learned counsel Mr. K.R. Patri is present for the respondent
Respondent number
number
2.
1, 2, and 3.
No, 3 lordship.
Okay, respondent number 1 and 2. Okay, learned counsel Miss
J. Akhtar.
J. Akhtar is present for respondent number
3.
3. It is submitted by the learned counsel for the respondents that the respondent number 1 has passed away. And the legal heir of respondent number
2 is the Malad.
One.
1 is respondent number 2.
2 and 3 also. 3 is the son, 2 is the husband.
Husband.
3 is the driver owner.
Yeah, it was in the same.
Or legal heirs of respondent number 1 is the respondent number 2 and 3. Full stop. It is submitted that the name of the deceased respondent may be struck off. Full stop. After considering the submissions of both the sides, the name of the deceased respondent, Dipali Das, is struck off.
And
Already
Lordship,
fixed the matter for hearing, my lord.
already it was fixed for hearing, Lordship. The
It is submitted by both the sides that that there is no element of settlement between the parties, and this case may not be referred for mediation. This matter after puja vacation.
My lord. Date may be
This
fixed,
matter
my
for
lord.
hearing after puja vacation.
Date may be fixed, my lord. Long pending matter, my
Okay,
lord.
dated are
19.
18
My lord.
November.
All
Fully
right.
obliged, Lordship.
Yes, yes.
Item 31.
31 is.
That I am not facing it, Milord.
Mm.
I seek your lordship permission to withdraw the message.
Okay,
It may be dismissed on withdrawal.
item number 31. Learned learned senior counsel, Mr. D.P. Solia, is present for for petitioner and has submitted that. So Ali, vacate the interim order.
Yes, that is to be vacated.
The petitioner is not pressing the petition and has prayed for withdrawal of this petition. Respondents are not present. Notices have not been served.
Notice has been
Served. This was against, this order was against, this petition was against.
Against an order by which Milord, the petitioner was not given permission to time for examination. But in the meantime, the person has died.
Oh,
So in the
petitioner has died.
petitioner.
Oh, that person
The
who
person who has to be examined,
cross-examined has died.
he has died. So in view of that, Milord,
Okay, it is submitted that this petition was against the order passed by the learned trial court in TS
Well-
number
1 of 17, Milord.
1 of 17, whereby the learned trial court did not accord an opportunity to the petitioner to cross-examine PW.
Here is 1.
PW1. First of meanwhile, PW1 has passed away, and
Ah.
thereby the petitioner is not pressing this. Petitioner has paid for withdrawal of this petition. Petition is hereby dismissed on withdrawal. Interim order stands vacated.
Vacate. Fine.
Will you refer to mediation?
No, actually, a conversation is going on regarding the compromise, Your Lordship. May it fix on another date before that if it is settled.
Without going to the mediation?
Yes, yes, you can compromise.
As requested by, as submitted by learned counsel for both the sides, list this matter after puja vacation.
Yes, Lordship. Yes. Applies.
Item 15.
My pleasure.
Mediation?
Yes, Lordship. it can
Your
be
lordship,
referred.
your lordship, no, this is, I am appearing on behalf of Mr. R.C. Pal for respondent number 1. This is appeal against the order of dismissal. So insurance company will never settle these kinds of matters.
As your Lordship pleases, my lord.
Learned
Because
counsel,
the ground for dismissal is that negligence of the driver is not proved.
M.U. Mondal. Learned
No, your lordship, I am appearing on behalf of R.C. Pal.
Learned, on behalf of Learned Counsel, Mr. R.C. Pal
Yes.
has submitted that there is no element of settlement in this matter and then this matter may not be referred for mediation. List this matter after Puja vacation.
My lord, I am for defendant number.
Okay, what is your name?
N Nasrin. Defendant number 12.
Learned Counsel, Ms. N. Nasrin is present for respondent number 2 and 3 and Learned Counsel, Mr. N. Ahmed.
MM Zaman.
M.M.
Zaman.
is present for the appellant.
Oblige, Lord. Oblige.
Mediation or no mediation?
Your lordship,
No mediation.
no mediation, and there is one IA, your lordship. The amount was deposited way back in the year
No,
2000.
no. Not today. Today is only for mediation.
No, your lordship.
No. For referral to special mediation drive for the nation, not today.
As your lordship pleases.
Cannot. Both the parties have submitted that there is no scope of settlement and the matter may not be referred for mediation. List this matter after Puja vacation.
Your lordship, the IA is pending since 2023.
See, next week I cannot fix this matter. And these 2 days I cannot fix this matter. After Puja vacation, I can fix a date if you want a short date. Item 17.
Your lordship, the amount was deposited in the year 2023. From 2023 till today, I am losing the
Not
interest. I
today,
am the
maybe
widow.
next, maybe, if done, দিব পাৰিম। নাই, next week ত দিব নোৱাৰি, কাৰণ এইটোতো হেৰি।
Your lordship, I am losing interest. I am the mother of the deceased.
Very
I
sad,
lost
but-
my son. So your lordship, the amount was deposited in 2023.
No, I
So-
cannot take up the IA today. This is.
No,
for-
I'm not saying, let the matter be fixed in the next week. Any date, your lordship, please.
List this matter
Maybe-
after 1 week.
Your lordship, may please to fix a date, otherwise.
This matter is changing at the stage of motion.
Appeal has been admitted, stay has been granted, subject to 50% deposit, but no release order was passed. I filed this IA on behalf of the claimant in the year 2023 for
They did not give it.
highly obliged.
One here. Will refer for mediation?
No, my lord, this is not fit for.
Learned Counsel, Miss
L Sharma,
El Sarma, on behalf of.
insurance company, Reliance,
Learned Counsel, El
Reliance
Sarma is present for-
insurance company.
present for the insurer
There are two insurance company.
and has submitted that there is no scope of settlement. What happened? No scope of settlement?
No scope.
No.
Two companies are involved here.
Learned Counsel, Mr. S.K. Potter is present for the appellant.
Lordship, I have another submissions to make, Lordship.
I am not today. I am not today.
It may be fast if Lordship, because one IA is fixed today, Lord.
But this was for only referral matter.
Mediation.
Tomorrow, day after tomorrow, any other day.
As your Lordship. Another matter in the order 2023, Lordship, 2022, one order was passed in IA 2625, directing them to pay 25% amount. But as the order was not
Not
uploaded
reflected, uploaded, my lord. That's why, my lord.
What?
in IA 2625,
Why
2020,
not reflected?
I was
Not
disposed
uploaded?
of, but order was not uploaded.
Oh, what?
On verifying the record, it comes to my notice, Lordship.
Hmm.
As the order was not uploaded, I have checked
What is
the,
disposed of?
I have checked in the CIS system also.
Hmm.
So that's why they could not make the payment, Lordship. 25% of the total of their liability.
Hmm. The upload code.
So that can be an order maybe in
Maybe past, my lord.
this MSC 602, Lordship, appeal.
Hmm.
That can be reflected, Lordship, in the
Hmm.
MSC appeal itself, Lordship, that they have not paid. And their submission. will be that
That's why
it
we
will
have
be
not paid,
approved.
my lord.
Okay. This I has not been listed because it has been disposed of.
It has, that's okay, order has not been uploaded. My
It is-
submission may be
it is
recorded, Lordship.
submitted by both the sides that
In
the-
MSc main appeal, my submission may be recorded.
that the order dated 31/8/2022 in IA number 265/2022 arising out of MSc appeal 602/2022 has not been uploaded, and that is why the insurer
yes,
was unable to
insurance.
deposit the
Award,
award.
25% of the awarded amount.
That deposit 25% of the awarded compensation to stop the order to be uploaded.
Lordship.
Order to be uploaded in the website.
Yes, ma'am.
Day after tomorrow, Lordship. So for the IA, this condonation of delay petition, Lordship.
Condonation the
Yes, only 20 days condonation in the cross objection, Lordship. In same, we have got two appeals on
not
the
tomorrow, day
same
after tomorrow.
accident.
Day after.
Day after.
Lordship.
Obliged, ma'am.
Release this matter day after tomorrow.
Yeah, please, your lordship, the consent of other side, I'd like to pray for adjournment, your lordship.
Adjournment may be allowed, Lordship, for the petition.
Owner Council, Mr.
I am A.R. Shom on behalf of S. Chauhan. A.R. Shom,
A.R. Som on behalf of Learned Council, Mr.
H. Chauhan.
S. Chauhan, with the consent of the other side, has prayed for adjournment.
My lord, I am appealing for the state of Assam for
P. Muzumdar.
23 and 24. Respondent number 23 and 24.
P. Muzumdar.
No, K.K. Bhattacharya.
Learned Government Advocate.
Yes, government advocate.
Learned Government Advocate, Mr. K.K. Bhattacharya is present for respondent number 23 and 24.
23, 24.
Learned Council, Mr.
I Bhattacharya.
My lord, my lord may record it, that may dispose of the case. After I have seen the file, it is a government land. So if the both parties, they are taking time today, both of them, if they can talk them out, talk and have a compromise, it will be good, my lord. Because it is not a case I saw today, I read today, it is not for the High Court and for the state of Assam to get into, man. At a government land, they are fighting, a lot of people are there, my lord, like a crowd. So best they talk it out, my lord.
Lordship, I'll have to take assistance from its senior.
Yeah. So my lord may record that the government view, my lord.
He will have to inform his senior, no point.
Yes, yes.
Learned Council, Mr.
I Bhattacharya.
is present on behalf of
P. Dekar.
Learned Council, Mr. P. Deka, for the representing the appellant. When to release the matter?
After vacation, lordship.
Release this matter after push vacation. Item number 19.
May I please, your lordship. Lordship, this is statutory appeal, section 96 appeal, your lordship. The appellant is the defendant. The suit of the plaintiff's respondent was decreed, your lordship, for preliminary decree. Partition suit was that.
Will admit it.
Lordship.
Decreed by
By decree,
Civil Judge Senior Division.
Civil Judge Senior Division, Jorhat.
Hmm?
Civil Judge Senior Division, Jorhat. In TS number 55 of 2014. It is at page 2 of constitutional.
P. Som, no?
A.R. Shom.
Learned Council, Mr. A.R. Som is present for the appellate. The appellant is agreed. Appellants.
Appellant.
The-
One appellant.
But there were many respondents.
Lordship, defendant number 5, I was the defendant number 5, I have preferred this appeal, your lordship. And in respect of others defendants, some were proceeded ex parte.
Appellant Srimati Smriti Burwa. The appellant is agreed by the judgment and order dated.
Judgment and decree 27/5/2025.
Judgment and decree dated. .
27/5/2020.
7/5/2025 in connection with TS number 55 of 2014. Admit, issue notice to the respondents, returnable within 4 weeks, list accordingly.
Lordship,
Call for the
TCR.
call for the trial court records.
Lordship, there is IA, your
Will
lordship.
take up later.
Lordship, because kindly see your lordship, this is preliminary decree, your
We
lordship.
should take up later. Partition there.
Yes, but there is a direction. Kindly, like, lordship, your lordship, have a look at.
To issue precept.
Yes, so the lordship.
Okay.
Precept has been issued. Page 41 in the IA, your
No,
lordship.
I लिख दिया. Learned counsel, Mr. A.R. Somis,
Yes,
present
your lordship.
evidence Smriti Barua, who is agreed by the judgment and order dated 27/5/2025, passed by the learned civil judge senior division and Jorhat in connection with TS 55 of 2014, whereby the suit of the opposite parties plaintiffs has been decreed and precept has already been issued. Full stop, it is submitted that, which page?
Page 41, your lordship, in the IA. Paragraph first, second, and third.
Paragraph?
Let's prepare a paragraph first, second, and third, your lordship. Issue precept
It
to
is submitted
district
that
commissioner.
that the order dated 25/5/2025 clearly reflects that precept has been issued for cancellation of the mutation of schedule A lane in favor of defendant number 5, who is the present appellant.
Yes.
Applicant, full stop, it is submitted that the entire appeal will be rendered infructuous if the stay is not granted. Full stop, the applicant will suffer from irreparable loss if the deputy commissioner proceeds now with the order of precept. With the order of issuance of precept, full stop. It appears that stay may be granted at least till the next day of listing. Issue notice to the respondents, reasonable within 4 weeks. The operation of the impugned judgment and decree dated 27/5/2025 is stayed till the next date of listing.
Oblige, your lordship. Lordship, earlier one date was 25, it was, it ought to have been 27/5, your lordship. 27/5.
27/5/2025.
Oblige, your lordship.
No, not present. You are a caveator?
Yes, Lordship.
Okay. Should I discharge a caveat?
Lordship.
Caveator is present, caveat is discharged. Petitioner or appellant is not present. Caveator on behalf of respondent.
All
respondents.
all responses.
On behalf of all the respondents. Now I caveat to Katidia. Learned counsel, Mr.
W. Hawk.
W. Hawk is present on behalf of the respondent.
Mr. Asafar.
Uh,
Yes.
Respondents, within bracket caveator, bracket close. After vacation,
Okay, Lordship.
please this matter after puja vacation.
I can send you one.
Oblige, Lordship.
I'm the petitioner, Your Honor, Your Lordship, or the FAO 59/25. Your Honor, I prefer adjournment because we are going to file a stay petition along with the FAO. So, Your Honor, we prefer adjournment fully.
Okay. Learned counsel, Mr.
And Bhaiya.
And Bhaiya has paid for adjournment. List. List this matter after puja vacation.
Oblige, Your Honor.
Item number 22.
Charge sheet submitted. 22.
Petitioner is not present.
No.
Petitioner is not represented. Learned additional people, Mr. K.K. Das is present and has submitted that charge sheet has been laid against the petitioner. List this matter after next week. List this matter or date at a deal.
Item 23.
May I please, your lordship? City was called for. It is here. So this is the third time bail application. And new ground in this case, on earlier occasion that city revealed
One,
that.
two, three.
My
New
lord.
ground every,
My lord.
well, read out the.
However,
lordship,
in this case, lordship, the last date of the rejection is 12/8/2025. And here it is, the last date of the entry is 36/2025. 36.
12/25,
Yeah.
1 month, only 1 month.
So new ground
And
is
the last date of entry is 36.
36. Then otherwise.
Last date.
Yes.
After that, no investigation is going on. 36 June, in the month of June, we'll need the updated CD at least,
Yes.
and no call, no interim bail,
Yes. My lord.
103.
My lord, update us.
CD is not up to date, send back the CD, call for the updated CD, list the matter on, which Thana?
This is
vacation
Kamulpur.
Will
Kamulpur.
it
Before
come on
vacation, any date?
I don't think so.
No, not after vacation. Before vacation, যদি পারে।
14th October, first day. the
First
vacation.
date, madam.
Or do you want on 13th, we can fix it on 13th also.
No.
13th October.
No.
Item number 24. For hearing under.
May it please the lord. No, this is the regular second appeal.
Have I heard you before on this?
No, press matter. The regular second appeal matter. Basically, my lord, in brief, the case is like this, my lord. Initially, my lord, there were 3 pattadars. Lordship will kindly see page number 13. There were 3 pattadars, my lord. Santi Devi Kedia, Ganga Devi Kedia, Syamlal Kedia. These pattadars, my lord, had land.
Number? Page number?
Page number 13.
3030.
13. So, my lord, these 3 pattadars had several plots of land in 3 dags, 70, 71, 72. From these 3 dags, my lord, they sold land to the plaintiff. My lord, in brief, my lord, I mean a nutshell, my lord,
It's okay.
these 3 pattadars, my lord, sold several plots of land to the
Page number 13, who are the pattadars?
Well, that is in the main suit. These plaintiffs, my lord, they purchase these lands, some lands from the original pattadars.
Okay.
Thereafter, my lord, these plaintiffs, my lord, then they again sold some land to the defendants, some of the defendants. Defendant number 1 to defendant number 15.
Okay.
So, what happened was that after that, some addition, the other defendants, their story was that the plaintiff story was that these defendants, some of the other defendants, who did not have any title, they tried to encroach upon the land of the plaintiff. They tried to dispossess the plaintiff. So the plaintiff filed a suit against all the defendants. These defendants filed a written statement, but that was not considered by the court. It was not brought on record. Subsequently, the suit was decreed
In favor of the plaintiff.
in favor of the plaintiff. Lordship will kindly see the operative portion of the judgment at page number 35. The suit of the plaintiff is decreed on contest with cost, ex parte against the other defendants. So these defendants did not even file written statement. Their written statement, even if they have filed, was not considered by the court.
So the suit was decreed ex parte. Now, our case is that, my lord, this appellant is a third person. He was not a party in the main suit. So he filed an application under Order 21 Rule 97
Yes, okay.
in the before the executing court. That, my lord, petition, my lord, is at page number 46.
So this was decreed ex parte.
Ex parte. Ex
And
parte.
third party has filed
Before the executing court.
after this first decree
Yes.
in the title suit.
Yes.
Then this case went to the executing court.
Yes. For execution of the decree.
There
There
was
is
no vacation of ex parte order.
no. Even if it was, it will be against the main defendants. But I do not know whether the main defendants file an appeal or not. But in the executing court panel, this person, he said that he was a
Purchaser.
not purchaser, he was a ryer. That means he was an occupancy tenant. But he was not made a party in the main suit. And his right was not determined. So that was his contention before the executing court. Now, if your lordship will kindly see Order 21 Rule 97.
Yes. Can file.
Can file. And all the questions, the procedure is at 101, Rule 101. That says that, my lord, all the questions pertaining to that will be determined by the executing court and no separate suit need to be filed. Before amendment, it was that only the recourse was to file a separate suit. After amendment, the executing court has been given the power that the executing court can determine all these. Now, this determination will be more or less like a suit. Even issues need not be framed, but at least both the parties should be given opportunity to adduce evidence. And after that, the court will, because to save time and also to prevent multiplicity, that, my lord, if your lordship will kindly see 101.
So one miss case was registered.
No miss case was raised. Says that all questions arising between the parties to a proceeding on an application and relevant to the execution shall be determined by the court dealing with the application. That will be the executing court. Now, our case is that, my lord, without even giving any opportunity to this petitioner, that petition was dismissed. Because otherwise, his claim is that his claim was independent to any of the defendants. He was a riot, and the court ought to have given him an opportunity to adduce whatever evidence he had.
So earlier he filed petition under Order 21 Rule 97.
Rule 97.
This petition was dismissed.
Dismissed. Thereafter, my lord, he preferred an appeal. If your lordship will kindly see the last page. Last page, but 76. The impugned judgment passed by the appellate court. The appellate court goes on to say that the executing court even cannot go behind the decree. That is totally absurd, man. The executing court definitely has the power. Lordship will kindly see paragraph number 11 at page
No,
number 7.
See, decree or that always not absurd. You cannot go beyond decree.
Yes, we cannot go. But at the same time, the executing court also must
Page.
at 76. That is a different principle, man. 76.
Page 76. Okay.
Yes, the law is very specific that executing court cannot go behind the decree. The decree which was obtained by decree holder after a long fight cannot be denied to enjoy the fruit of the decree. Yes, it is true. But at the same time, the court will also must dispose of any question regarding the right, title, and interest of any person who was not allegedly made
So
a party.
miss case was not filed.
Miss case was not registered, and the court, without giving an opportunity to the appellant, dispose of that petition, and also the appellate court.
Where is
confirm.
your ground?
Ground, my lord, is at page number
Not ground.
substantial question of law, my lord, at page number 11.
11.
Just a moment. Then you have preferred an appeal.
Yes,
Where is the, oh, this is the order.
yes, yes. Because it
Oh,
is,
so this is, you have preferred an appeal before the
yes,
district judge.
yes.
And the
Because that
district judge
order,
has passed this order.
yes, that order amounts to a decree.
No, no. His father has contested the suit as defendant.
Yes, but that is one issue, my lord. But then also, my lord, he's right. Whether his father contest, whether he has independent right on his own or not, that will come only by reducing evidence, my lord. At least who has seen. Who's, it's ultimately it's a suit within a suit. The order to 21 Rule 97 proceeding will have all the necessary features of a civil suit.
Substantial question of law, but I won't stay.
Yes.
I will not stay.
That one question is enough, my lord, in this case, my lord, whether the proper procedure was followed or not by the executing court in disposing of that application. That will suffice, my lord.
Okay. But I'll not stay.
My lord.
My lord, as per telephonic
Oh, yes.
instruction, my friend
You are the
earlier.
caveator?
Yes, as per
Okay.
telephone instruction yet to be filed
Okay.
forward. Let them notice may issued,
Notice is issued for
notice
a
may
day-
be issued regarding second
No, no.
appeal lawsuit.
I'm not granting stay, only
Or
one
lawsuit.
question of law. I
Lawsuit.
admitted on only one
Lawsuit.
question of law.
My lord.
Lawsuit.
Only one question.
Lawsuit.
And I'm not granting stay.
My lord.
And that too
Other-
at the execution stage.
Lordship has gone through father, mother contested, same property. He himself stated in his petition, same property.
That application, my lord, will have.
I'm framing substantive
My-
question. That this application should I dispose it of or I'll
No,
fix
it will
another
be
date?
kept pending, my lord.
Learned counsel. Learned counsel, Mr. S. Das is present on behalf of the appellant, who is aggrieved by the judgment ex parte.
No,
Oh, no, not ex parte.
not that one.
Who is aggrieved by the, we must go to the title appeal, no?
Title appeal.
Aggrieved by the order dated judgment and order dated
My lord, this 25/6/2025.
2025
Ask in title appeal.
title appeal number 2
Two
of
of
2024, upholding the order dated 29/7/2024 passed by the learned civil judge. It was about the learned district judge, passed by the learned district title appeal, passed by in 2 of 24, passed by the learned district judge in title appeal number 2 of 24, learned district judge South Salmana Mankacha. Upholding the judgment and order dated 29/7/2024 passed by the learned civil judge senior division South Salmana Mankacha in execution case number 2 of 2021.
24, my lord.
No, that execution,
Oh.
title execution
Title
case.
is
Where is the substantial question of law?
at page number 11, my lord.
Page 11 of Sabah. This appeal is admitted on the following substantial question of law. Page number 11.
But 2 will be sufficient.
Okay, number 2. Learned counsel, Mr.
F.U. Borbuya,
F.U. Borgia is present on behalf of the respondents.
respondents.
Full stop. Issue notice to the respondents, returnable within 4 weeks. Call for the records
Record.
of, you want the title suits also?
Title should record.
You want it?
Title, yes. But I'm now
Execution
title appeal record.
record scan copy may be lost. That
Execution record,
execution
my lord, scan copy will be sufficient, my lord.
scan copy.
Regarding title appeal, the original record will be required. Title
Title appeal.
appeal.
Title appeal number?
They have not preferred any title appeal.
No, not title appeal.
No, title
Title
appeal.
suit.
Title appeal was preferred.
No.
Yes, title appeal number 2 of 2024.
Yes, then.
And scan copies of records of title exhibition number 2 of 2021. Anything else?
No.
It caveat ki discharge bhi bila.
Caveat?
No, caveat nahi.
No, caveat.
Okay.
My learned friend will is
Serve a copy. Well, I'll serve a copy.
serve copy to.
Extra copies to be furnished. Learned counsel is present on the hearing. Extra copies to be furnished. Issue notice to respondents. Return within 4 weeks.
Highly obliged.
Obliged.
Wait, please, Your Lordship. Lord, the appellants were defendants in the original suit, right? Now, my lord, the suit essentially was filed by the respondent plaintiff challenging a gift deed in my favor, which was executed way back in the year 1983. Just to indicate the prayers, if your lordship turns over to page 18, my lord.
Yes.
Para 15 are the prayers, my lord. A is declaration of title, right title and interest. B is a decree we passed declaring that the registered gift deed number so and so is a forged deed and has no validity in the eye of law and liable to be cancelled. So that is the gift deed in my favor. And lastly, they also claim recovery of possession at the prayer C1 that was subsequently added by way of an amendment. Now, my lord, we filed the written statement alleging that the gift deed was genuinely executed by the father of the plaintiffs, and the gift deed having not been challenged within the period of limitation, the suit itself was barred by limitation. Now, the trial judgment, your lordship finds at page 26, my lord. And if your lordship has page 36, your lordship will find the issue of limitation.
I have asked for supplementary cost is put.
There's a separate IA for stay which is listed in the supplement. Now, my lord, if your lordship has page 36, my lord, that is how the issue of limitation was dealt with.
Page
36.
Okay.
My lord, the defendant pleaded that the present suit is time barred as after lapse of 33 years, the plaintiff filed this false and concocted case and tried to establish a false claim. The plaintiffs inter alia sought for recovery of possession of Schedule B land of the plain from the defendant on the basis of the title thereto. Recovery of possession being the principal relief, the present suit shall be governed by Article 65 of the Limitation Act, for which the period of limitation is 12 years. And the time begins to run from the date when the possession of the defendant becomes adverse to the plaintiffs. However, the defendant did not claim adverse possession of the suit land. In the absence of any specific plea of adverse possession, the suit must be filed within the period of limitation. This issue is consequently decided in the negative. The first ground is ultimately your principal prayer is setting aside that instrument of gift deed which is in my favor. So therefore, the trial court wrongly applied Article 65 because Article 59 was applicable, which says 3 years to cancel an instrument. Now, my lord, the subsequent issue on the following page, your lordship will find whether the plaintiffs have right, title, and interest over the suit land.
Which one? Issue number?
Issue number 3.
Okay.
Now, if your lordship turns over the page 38, para 25, the plaintiffs have exhibited the certified copy of the registered gift deed number 3577683 dated 7/6/1983 as Exhibit 2. PW4 Bharat Chandra Das, being extra writer, Office of the Deputy Registrar, has duly proved Exhibit 2, that is the gift deed, and stated that the same was issued from their office. From the evidence of the plaintiffs, it can be inferred the plaintiffs have right, title, and interest over the Schedule B land. The above evidence of the PWs remain unchallenged, unrebutted. The evidence of the PWs goes to show the plaintiffs have right, title, and interest over the suit land. So the basic allegation of forgery was not even dealt with. The gift deed was a registered gift deed, and nevertheless, the gift deed was cancelled. Now, against this particular judgment, my lord, we filed an appeal, and the appeal was barred by time.
Okay.
Now, the condonation application was preferred on the ground that my lawyer concerned did not really inform me about the outcome on time, and hence the delay should be condoned. That condonation application was dismissed, and the rejection order, your lordship finds at page 60.
Now that ground has been considered at para 15 and page 65, my lord.
Page 65, para
15, 1-5. The certified,
Yes.
has your lordship found it? Para 15, my lord.
Yes.
The certified copies of the orders in the title suit number so and so shows that the petitioner contested the suit by filing written statement on 7/10/2016. As already mentioned, the judgment was delivered on so and so after about 6 years of filing the written statement. But the petition filed by the petitioner is silent as to why the petitioner did not take any steps against his engaged counsel if the learned engaged counsel was not conducting the trial properly during this long period. There is no satisfactory explanation by the petitioner about the steps taken by him while his engaged counsel repeatedly avoided to update him about the status of the suit. Being aware of the pendency of the suit, it was the duty of the petitioner to remain vigilant about the progress of the trial. Failure to do so, do the same for a period of 6 years only means that the petitioner was negligent and inactive. Now, my lord, here the condonation was rejected on the ground that during the trial, you did not really participate and you were not vigilant enough, and you ought to have maintained some sort of a communication with the lawyer. Now, the fall that I'm trying to place is the condonation period of limitation would commence from the date of judgment. So what my conduct was before that, during the trial, was not even a relevant consideration insofar as Section 5 is concerned. So now your lordship is aware of that judgment which says that if the condonation is dismissed and consequently the first appeal is dismissed, a second appeal would lie, which is how we are here, my lord. And the proposed substantial questions of law, your lordship finds at page 8.
No, against this condonation, dismissal of this condonation order,
Yes.
you could have preferred an dismissal of condonation of delay.
Yes, yes.
Yes. Then you could have come against this order of dismissal.
My lord, in fact, there are judgments which have said that when you dismiss a condonation application, you are ultimately dismissing the appeal. And
Yeah, you're dismissing the appeal, yes.
so if it's a decree, then it becomes appellate. It becomes a decree in the appeal. So therefore, courts have consistently held that it'll be a decree in the appeal itself.
You do not prefer any, you haven't come against the order of condonation.
Order of condonation have come, but that will be treated as a decree now. Since because ultimately dismissing the condonation amounts to dismissing the main appeal itself. So therefore, the second appeal. That was held in Shamsundar Sarma, relying on the earlier judgment. Paragraph 8 to 10, if your lordship sees. Paragraph 8 was the question formulated. The head note is clear, Manu. Anyway, if your lordship has para 8.
Yes, paragraph 8, yes.
The first question to be considered is whether an appeal accompanied by an application for condonation of delay in filing the appeal is an appeal in the eye of law, and when the application for condonation condoning the delay in filing the appeal is dismissed and consequently the appeal is dismissed as being time barred in view of Section 3 of the Limitation Act. There was conflict of views on this question before the High Courts, but the Privy Council so-and-so has said there is no definition of appeal in the Civil Procedure Code, but their lordships have no doubt that any application by a party to the appellate court asking it to set aside or revise a decision of a subordinate court is an appeal within the ordinary acceptance of the term, and that it is no less an appeal because it is irregular or incompetent. Paragraph 9. the specific question involved came to be considered in the case of Nelaram and Sons versus CIT. This court held that an appeal presented out of time is an appeal, and an order dismissing it as time barred is one passed in appeal. The court referred to and followed the view taken by the Privy Council and by this court in the two respective decisions above referred to. The court quoted with approval the observation of Chief Justice Chagla in so and so. Although the appellate assistant commissioner did not hear the appeal on merit and held the appeal was time barred by limitation, his order was under section 31. And the effect of that order was to confirm the assessment which had been made by the income tax officer. And finally, paragraph 10. The question was considered in extenso by the full bench of the Kerala High Court in Thambi versus Matthew. Therein, after referring to the relevant decisions on the question, it was held that an appeal presented out of time was nevertheless an appeal in the eye of law for all purposes, and an order dismissing the appeal was a decree that could be the subject of a second appeal. It was also held that Rule 3A of Order 41, introduced by the amendment of 1976, did not in any way affect that principle. An appeal registered under Rule 9 of Order 41 has to be disposed of according to law, and a dismissal of an appeal for the reason of delay in its presentation and after dismissal of an application for condonation of delay is in substance and effect a confirmation of the decree appealed against. Thus, the position that emerges on a survey of the authority is that an appeal filed along with an application for condonation of delay in filing that appeal, when dismissed on the refusal to condone the delay, is nevertheless a decision in the appeal. In fact, there were conflicting views earlier, and that is how Shamsundar settled it. They said ultimately, if you dismiss the condonation, you are ultimately dismissing the appeal.
Yes.
And if you are dismissing the appeal, you are affirming the judgment of the trial court, and hence a second appeal would lie. Now, my lord, the questions first is even for the first question, there is also a judgment of the Supreme Court which says that you must not focus on how the conduct was prior to.
That is not required.
Yes, yes.
That was not required actually.
Yes, yes.
But relating to this, I'll have to ponder over it, ponder over the matter before framing any substantial question of law.
My lord.
I'll have to. What are your questions?
My lord, paragraph page 8.
Okay.
Page 8, first is the regarding the condonation. Then perhaps 2 your lordships can skip, and number 3 and 4 would be relevant, my lord. Whether Article 65 was applicable, because it was essentially because ultimately if you don't cancel the gift deed, you cannot declare title. For cancelling the gift deed, it is Article 59 rather than 65, which was wrongly held to be applicable.
That we can take up.
Yes, and lastly, my lord, the gift deed your lordship has seen is a registered gift deed. The registrar has also endorsed it, and there are in fact no findings of forgery. If the court would have even said one line that the signatures were forged. In fact, there's a recent judgment, not so recent, 2021, which says that registered instruments will carry a presumption, and it is for the plaintiff to discharge the owners. And hence it was there once the registration was proved.
These are paragraph 8, 9, and 10 you are referring to in the condonation of delay, that judgment.
Yes.
Shamsundar's judgment,
Shyam
paragraph
Sundar.
8, 9, and 10.
8, 9, and 10. That's correct.
And this?
And this is in support of my substantial question of law number 4.
Paragraphs?
The 33.
Okay.
So, my lord, now that the trial court judgment has merged with the order passed in the appeal, in fact, the trial court findings are also vulnerable in a sense that they did not, with respect, the learned trial court did not even go into the main issue as to whether 1983 deed was genuine or not. Where no discussion, no findings were rendered. It perfunctorily held that the title is referred. The only anxiety is when the execution case is fixed on Monday, 22nd, which is why we've moved that
Execution cases fixed for what?
for huh? Writ.
Writ has been issued, no?
Writ has not been issued. We've informed the court.
Okay, initial stage.
No, my lord, nowadays.
Order before that.
My lord, 22nd, in fact, we had taken time on the ground that we are moving this appeal here, so let it be held.
Writ has not been issued. Writ
But-
will be issued, then you will, or there has to be an order of attachment.
My lord, only difficulty is your lordship is aware of the latest Supreme Court guidelines, 6 months disposal of execution cases, which is why the executing courts hardly
Yes,
accommodate.
yes.
So because I think it said that it may entail proceedings against the
Yes,
officer
because-
concerned.
yes, yes.
So therefore they
Because-
hardly,
Because these cases were pending. for
yeah,
21 years.
exactly. So they hardly accommodate nowadays, my lord, given the direction. And in any case, my lord, if your lordship feels that it is capable of being admitted, this has serious consequences because ultimately it's a decree for cancellation of the gift deed also. And then the gift deed of nearly 33 years old, 1983, my lord. And then recovery of possession is also
Today is 17th.
to 17.
Pass an order. Before 22nd, I'll pass an
Oh,
order.
no, very good, very good.
I don't know what order. I'll
Oh,
pass,
I understand.
But I'll pass an order.
Well, there's the other judgment in support of the substantial question of law
Yeah.
1 that the court should, which period the court should consider.
That-
Not, I'll
If I'll pass the order, that is not required.
Right.
Or else if you want to.
No,
submit,
it's
then
okay.
you
We
will
will not trouble you. Lord. Obliged.
কিন্তু এইদিনৰ ভিতৰতে দিব লাগিব। Saturday ভিতৰতে।
Yes, Your Lordship. This is second appeal filed against the judgment on order dated 20/12/2024. TA number 70/90. What happened, Your Lordship? In this case, previous to their suit, there was another suit filed by one. Now, this is in the execution proceeding TEX number 8/2005. In this suit was ex parte and decree had been passed in favor of the Station Road Bonomali. My question is that if Station Road Bonomali filed the suit is for Masjid property and civil.
No. This is you come against execution proceedings.
Your Lordship, thereafter came to know the same. Thus, Bonomali Station Road filed a suit. Now I filed a suit. Suit is TS number 126/2005. The same has been dismissed, but no trial court has been not discussed about the title execution which was filed by Station Road Bonomali, which is a masjid property. And nowhere it is discussed, the civil court has no jurisdiction. Thereafter, I filed title appeal. Title appeal also dismissed. But nowhere it is discussed that the suit properties belong to the masjid property. And if the suit is masjid property, there is another board which is Waqif board. Under section 85. Under section 85 of the Waqif board, civil court has no jurisdiction to entitle suits or legal proceeding related to Waqif property.
You see, you are the plaintiff.
Now I am the plaintiff.
So in your plaint, have you mentioned that the suit is a masjid property? Suit land is a
No,
masjid property?
if they have, in their written statement, they have admitted that the suit is for the masjid property. And Noor Ahmed is the mutlabi of this masjid.
In the written statement?
Yes,
you have admitted.
Your Lordship, written statement, page number 15. Page number 16. that the abutment of para 1, 2, and 3 of the plaint are false and incorporated, and the answering defendant denied the same in toto. That the plaintiff has not locus standi to file the instant suit against the answering defendant or any other defendant. The abutment of para 4 and 5 false and incorporated, and the answering denied the toto. It is absolutely false statement that Noor Abdul Noor, who is the mutawalli of the answering defendant masjid, recently circulated the plaintiffs shall be evicted from the landed property of Dag number so and so, that the abutment and allegation of the plaintiff as
So where is the plaint? Where is the plaint?
plaint is page number page number 9.
You have given the schedule, no? In the
Yes, only
Which
0.7 decimal.
Huh?
Schedule is 0.7 decimal, which is mercy land, which is, I said, plaintiff said this is his property. Eh?
Which is the suit land?
Suit land is page number 14.
14 is which one? The schedule.
Yes, your lordship.
Where is the schedule in the in the
Titles.
WS?
Title suit, WS no schedule has been. There is no schedule in WS.
Then we will go to the judgment then.
Yes, hello.
Judgment of the appellate court.
Yeah, judgment. No one discuss about the
Where is the WS? Just give me the page again.
WS is page number 15. Starting for page number 15.
Where you have admitted that the suit property is under the page 15, no?
No,
Where you have
WS is page 15.
Page 50.
Yes.
Where
And
in which para you have just read now? You have
page
admitted.
number 16 and page number 17. Page number 17, that the decretal land of TS number so and so is belong to Karimganj Bonamali Station Road, Jama Masjid. And the decree of TS number so and so in respect of the land of Dag number so and so is not in respect of land of at least Dag number so and so of the extension.
Which paragraph are you reading?
Paragraph 16, page number 17. In the written statement,
So there is another title suit.
yes, this suit is filed by the Bonamali Karimganj Bonamali Station Road Jama Masjid, which was TS number 2011, now 2001.
So
Now the
do
same
you-
has been.
Do you have the plaint of that title suit
No, your lordship.
or the decree
At present, I have no title suit of the same suit.
or decree?
No, but I know the title.
No, no,
execution.
knowing will not do.
No, no, no. Your-
Knowing will not do. Do you have, you are stating
No, I
that
have not.
this land belongs to the masjid, and then they have admitted in WS this land belongs to the masjid. So this land belongs to the masjid, it is fine, it belongs to the, if you have the decree, then I'll get to know. I want the
No.
schedule of the land.
At present, I have no decree of the schedule land. But schedule land is
No, no, no.
within the
Then you cannot
judgment,
say,
appellate judgment.
appellate judgment, okay.
Title suit judgment and the appellate schedule is given.
No, no. You are referring to another
Yes, yes,
suit in that WS. Another suit which proves that that this land belongs to the masjid. So
in this suit, they have stated
no,
that
this now they have not admitted anywhere in the plaint or WS. They have not admitted.
no admitted
In the
it.
W, no, not in this manner. Not in this manner. I do not have any documents here.
No,
You
I have
haven't
not
given
annexed
me a
any document regarding the title execution or title suit, previous title suit.
So how can you say that this has been
But
admitted?
they have in the written statement, they have stated all the things.
No, they have said, but it is not annexed with this record.
And that there, the WS, it proved that.
Yes, but
they had admitted.
That decree or that schedule of that land is not annexed with this record.
No, in the WS, they have stated that the scheduled land is fall under Dag number so and so, and this is the masjid property.
Okay. In WS, then
yes,
Show me which page.
Real factor, page number 19. That the page number 19, Your Lordship,
Yes. Page number 19, yes.
that the land appertaining to settlement dag number, khatir number so and so, dag number so and more so and
So
so.
this schedule is mentioned in the plaint.
Yes, my schedule is mentioned in my title suit. And in their WS, no, I mentioned their schedule, but they have said this is the Masjid property and this is fallen under their part. That's why the title execution is, but nowhere it is mentioned there's the schedule is Masjid property and the civil courts have no jurisdiction to attend the suit. This is my only point.
I'm not getting your point. I'm so sorry.
Your Lordship, Bonamali Jama Masjid previously filed title suit number so and so before the junior divisions Karimganj. And they have got that decree ex parte. And the decree is now TX number 8 of 2000. But they in that cross, they have admitted, they have filed the suit for Jama Masjid. I have certified copy of evidence and deposition.
I'm so sorry. I'm not getting your point.
Your Lordship, we go through the evidence.
But that
They have
you-
crossed, they have
No,
admitted.
but you'll have to submit along with this record.
This is
Separately, I won't be able to.
This is certified copy of
No, I
deposition.
understand, but you'll have to file along with this, along with your RSA.
Oh, no, I have not filed, but the certified copy is along with me.
No,
If you-
I cannot work on it. then.
Okay, if you said I have filed the certified copy of this with higher biscuits, IA numbers.
If you want me to take into consideration this, then you
Yes.
have to file along with. this
Okay, Your
record.
Lordship, I will file. later.
Then I'll give you a time. Okay.
Right.
Then I'll give you adjournment.
Yes, Your Lordship, if you know, certified copy, you say
Me-
that I have to
it
file. Okay.
Doesn't concern me only, any court or
Okay,
if
okay. Yeah, hi.
they will require, maybe you
Okay.
may require, may not require, I don't know. May require, may not require.
Okay, Your Lordship.
But if you insist on reflecting that, then I think you will have to mention it in the petition also. I mean, in the appeal memo also. We
And-
can, I don't know in what manner you have.
No, no, they have admitted their WS. That's why I mentioned the same. If they're not admitted, then the substantial question of not arises. They have already admitted this is the Masjid property I have get in decree in title suit number so and so, and the same is now execution proceeding. That's why I said the same. They have already admitted their WS.
I don't know, I'm not getting your point actually. I'm not getting it. If you read out the.
Okay, I am done with it.
That judgment of the appellate court, maybe I can understand.
Judgment no one mentioned it the same. I have, okay, I go through the judgments, the title appeal.
The decisive issue, if you can read out.
Okay. All issues are discussed negative. But nowhere, all issues are discussed negative, nowhere mentioned the properties belong to the Masjid property. Okay, I will read the same.
Page.
Page number 46. Plaintiff also came to know the principal defendant number 1 has already filed a title execution number so and so in the Court of Civil Judge Junior Division, Karimganj for getting khas possession of land. The plaintiff alleges that the schedule of the decree of title suit number so and so has been wrongly described. The plaintiff pleaded that defendant number 1 to 6 and 8, 9 have no right interest in respect of landed property and plaintiff are not bound by the judgment and decree of title suit number so and so and title execution or so and so. Hence, the plaintiff prayed to pass decree declaring the plaintiff have right over the suit land up to the extent of their respective share as successor of late Porindra Chandra Chakraborty and for further declaration that the suit number so and so was obtained collusively cost of the suit and other relief. Appearance of the upon issuing of summons, the defendant number one appeared and contested the claim of the plaintiff by filing detailed statement. The suit proceeded firstly again defendant number so and so by the order dated so and so. The suit proceeded ex parte again defendant number so and so by the order number so and so. The name defendant number 7 was struck out from the plain by the order dated so and so. The defendant challenged the suit on the ground that the suit does not have cause of action bad for waiver so and so. The defendant number 1 pleaded that the land of the title suit number appropriating settlement number so and so under Khatian number so and so of Mauja Karimganj township number 5 Mohor Dasman Taluk so and so. The contested defendant asserted that the land of C2 dag number so and so of the instant road is in west of the land of dag number so and so. Defendant number 1 pleaded that the TS number so and so was filed against the defendant, including the defendant number 7 of the suit. The plaintiff of this suit having no right, title, interest, or possession over the land pertinent to that number so and so, and have there are framing whether their issues are framed in 5. Now the plaintiff appellant side in TS number so and so adduced evidence and also exhibited document, and the defendant side also adduced the evidence and exhibited document in support of their case. The landed trial court having perused the entire case record and after hearing argument dismissed the suit of the plaintiff by judgment dated so and so. I have heard the argument forwarded by the Landed Council and I perused the case record and point for determination as surfaced in the instant case whether the judgment and decree number so and so is just proper in law. The purpose of convenience, it is deemed fit to scrutinize the impugn judgment issue as to adduce the point of determination whether there are any cause of action for the suit. Appellant plaintiff side is institute the suit by suit number so and so, stating that they have inherited the suit property from their predecessor Orindra Chandra Chakraborty. Plaintiff side pleaded that during the time of execution of title execution case number so and so from the Court of Civil Judge number 1 Koringan for getting khas possession of land. The plaintiff ought to know that the defendant side by virtue of judgment part in title suit number so and so trying to encroach the land property, and according the plaintiff side filed the original suit with a prayer to declare that the judgment and decree in title suit number so decided exclusive one. Defendant side also contested the suit and pleaded that the answering defendant number 1 filed TS number so and so in connection of dag number so and so pertinent in Khatian number so and so of Mauja Karimganj township number so and so, taluk number so and so, whereas the instant suit filed by the plaintiff side is in connection with dag number so and so, and accordingly prayed that the plaintiff has no locus standi to say. It is herein to be mentioned that I have perused the plaint of instant suit title suit number so and so as per plaint of the instant suit, the schedule of suit land pertaining to Dabnagar so and so Mauja Karimganj. I have also perused of the judgment and decree passed in Eto, which was admitted by the defendant side by Exhibit E, and on perusal of the same, it reveals that the suit land number so and so pertaining to Dabnagar so. Thus, under Sasaka, I do not see the plaintiff side had any reason for cause of action against the judgment and decree number so and so. As per the hence, the issue is decided against the plaintiff side and the decision error by the Landed Trial Court upheld. Issue whether the suit is maintained in present form and manner. I have perused the judgment passed by Landed Trial Court in TS number so and so, and I am in agreement with the findings of the Landed Trial Court that in the instance suit plaintiff did not have any right to sue. The judgment passed in so and so belongs to a separate dark, whereas plaintiff suit land belongs to a separate dark, and therefore there is no ground to assess the judgment passed in Eto. And I am in agreement with the findings of the Trial Court that the suit suffer from maintainability, and hence the issue is decided against the plaintiff. Whether the execution proceeding number 7 in respect of present suit land or dark number so and so, whether the judgment and decree of the title suit number so and so as obtained, there was the most vital issue, and further it is herein to be mentioned that issue number 3 and 4 are directly connected with each other and as such taken up together. Issue number 3 is also determined whether the title execution is in respect of present suit land of dark number so and so. The plaintiff as PWR in his evidence disposed that the also filed an application for staying the proceeding of TS number so and so, which was filed by defendant number 1 in pursuance to decree number 1. PW1 pleaded that principal defendant number one is trying to enforce the suit land of the present suit on the strength of the execution proceeding on perusal of the record. It is revealed that during the trial, Lanet Court got both the dogs at the survey by Circle Officer Karingan for identification of the boundary separating the land. The said dog by relying on perusal of the record, it is seen that the survey was done and the report along with relevant document was submitted before the Lanet Trial Court. The Lanet Trial Court also examined Amin, who conducted the survey report test map by Exhibit X2, Exhibit X3. As per Exhibit, it is seen that an area of 8 kata 11 chotak land is being covered by Dag number and on the surveyor the CW1 during his cross disposed that the red mark area is in possession of the plaintiff, which means is the plaintiff side occupying an acre sector of the land pertaining to at the time of argument. Land counsel for the appellant plaintiff side contended the survey was not done properly and Exhibit X does not reflect the actual status of the land. But apart from the said allegation, the plaintiff side could not dispose any other relevant document to show that the survey was not done properly. Moreover, from the evidence of CW1, it is appertaining that when CW1 surveyed the land, he did in the presence of the witness and parties of both the side and took their signature. CW1 during his cross-examination also disposed that he used the survey map and the document provided from the court while demarcating the dark amongst the Lanet Track also framed another issue to determine whether the judgment and decree passed in police practicing fraud on the court plaintiff side. Adduced evidence of PW1 reiterated the facts pleaded in his plaint. The plaintiff asserted that the plaintiff side title interest of the suit land toward their result with the appraisal of the plan. It is seen that the suit land of plaintiff pertaining the also under the 10 hours of had Exhibit 1 society submitted copy of boundary map in respect of the number so Exhibit 2, 3 at the land revenue received in respect of the suit land, whereas the Exhibit 4 series at the municipal urban improved property tax receive. I have perused Exhibit 1 and name of Sri Purindra Chandra Chakraborty found material for Dag number so thus on perusal of the Exhibit 1 to 4, and it is certain that predecessor of plaintiff had right, title, and interest over the suit land of the suit schedule mentioned in plan TS number so. Plaintiff in the plain TS number so pleaded to pass a decree declaring that the judgment and decree passed in so policy and to restrain defendant number 1 from encroaching the suit land of plaintiff. Though title execution number so the plaintiff is in plain pleaded that the cause of action arose when one Abdul Noor Booth calculated in the locality that plaintiff would be evicted from the suit land by the judgment of the defendant number 1 is Karimganj Bonamali Station Road, Jama Masjid, represented by Abdul Noor, the Mutawali of defendant number 1. Abdul Noor as DW1 adduced his evidence and pleaded that the suit land so-and-so is covered by Dag number so-and-so. DW1 stated that the plaintiff land is covered by Dag number so-and-so and situated west of the. On perusal of the Exhibit X, it is seen that both the land of Dag number so-and-so and so situated adjacent to each other. I have perused Exhibit 5, which is certified copy of judgment and decree in TS. On perusal of the exhibit, it is revealed that the defendant on earlier titles in respect of the against the rest of the principal defendant of this suit, but none of the defendants in the earlier suit contested when the ex parte decree was passed in favor of the defendant number 1. Further, on perusal of Exhibit 5, it is clear that there was 2 schedule of land and both the schedule of the land, namely 1 and 2, schedule pertaining to Dag number so-and-so and Khatia number so-and-so. Further, as already discussed, the land of Dag number so-and-so is situated on the west past schedule and TS number A is certified copy of final Khatia number so-and-so, which is certified copy of Tresma so-and-so. The landed trial court passed the judgment in favor of the defendant number 1, TS number so-and-so, confirming the right title in interest over the first schedule land and recovery of first possession to schedule land. The plaintiff side could not adduce any evidence to show that the judgment of the suit was passed by practicing fraud on the court. Moreover, from the judgment of TS number 7 and evidence on the court, it is very much clear that the land of defendant pertaining to HSL Dag number 7 instead of suit number so passed in favor of the defendant pertaining Dag number 7 in TS number 7. Also, during the cross-examination, testified the plaintiff had no claim over the. Hence, I did not see any reason to interfere with the decision arrived by the learned trial court. whether the plaintiff are entitled to, for considering the discussion and decision reached in the foregoing issue, it is found that the appellant are not entitled to any relief. However, it is ordered that physical demarcation of the land of the Agna be done for proper execution of the decree as per EX.
All right, yes. So what question of law has to be framed now?
Question of substantial question of law. Page number 6.
There is no substantial question of law in this case. That other title suit, that was not taken into consideration. We cannot own the title suit in this case.
No, your
Other title suit was not taken. That question was that which was raised in the trial court is that whether the decree was obtained fraudulently. So they have not, that is not required to be answered. The trial court and appellate court judgments are correct.
No, your lordship, trial court has no jurisdiction as per Waqif court.
No jurisdiction, trial court did not decide anything.
No, already the same has been executing court.
No, there's no substantial question of law. I'm sorry.
Your
Trial court has
lordship,
not decided anything on that other title suit.
no, they decided the suit is filed by Bonomali Station Road. On the first point, it is that is the Waqif property, and he is the Mutalib of different number 2 is the Mutalib. So this is the at first instance it is so that is the Waqif property. So civil court has not jurisdiction under section 85. How the civil court decide the matter
Civil
in
court has
favor
not
of the
decided anything.
in favor of the station Bonomali?
No, it has not been decided.
Yes,
They have
they are dictated
that
in favor
question
of the.
that was put before the civil court was that whether procured fraudulent.
This suit was expertise, that's why. The
No,
suit
no.
was expertise.
No.
Previous suit was expertise. That's why the question nobody raised there. Should if the suit
I'll
is
list this
contested,
matter-
then the same will
I
be.
do not find any substantial question of law. I'll list this matter for next week. You can place it.
The issue notice to the opposite party.
No, I'll not admit this case.
No, only issue notice.
No, I won't issue notice. I'll I'll list this case for another date. I'm not issuing notice.
No, your lordship, kindly see. The suit was filed by whom? The suit was filed by Bonomali Station Road, Jama Masjid. Instantly it showed that these Jama Masjids belong to the masjid property. A suit filed was one of the Mutalib. So in the first instead it showed that the suit is Waqif property. How they file a suit before the civil judge junior division? And in his cross, he has admitted that he know Waqif board is staying in
I'll
Guwahati.
fix one date. I'll fix one
And
date.
suit is filed before Waqif
I'll
board.
fix one date next week.
Next week I am not here, out of station, your lordship. Kindly issue notice to the opposite party.
No. Then after puja vacation.
So it is the execution is already done. Then how is the validity of the suit?
Next week.
It is infectious then.
Yeah, next week when you won't be here.
After puja vacation.
Then next week.
So
only
kindly
next-
issue notice.
No.
Only issue notice.
No.
Thereafter they appear and they
No. I'll fix a date on 22nd. You'll be here.
not
no?
issue notice, your lordship.
No.
Wait, kindly. Issue notice. No,
This
admission is
matter
not
on
necessary,
22nd.
but issue notice the opposite party.
No. Let's just matter on 22nd 9.
I can 27.
My please lordship, this is my lord second appeal,
Hmm.
filed under section 100 CPC against impugned judgment
dated 10/6/2025, passed by learned civil judge senior division Borpeta in title appeal number 9/2021. That is your lordship page 10. Here, my lord, the appellant were the defendant in the title suit. Title suit filed by the respondent by claiming
Page 10.
page 10, your lordship. This was passed on 10th of June 2025. Now, my lord, all this appellant are the son of late Nazrul Islam, and eventually this Nazrul Islam purchased land from one Pahar Khan. Pahar Khan is the original title holder, Afzal Khan's sons. And the respondent purchased one plot by measuring 1 biga from the original owner, Afzal Khan, in the year 1983. Sabzal Khan, your lordship. The respondent here, my lord, who is the plaintiff, Abdul, my lord, Matleb Mia, was the plaintiff in the title suit. He purchased 1 biga land from the original one.
Which one? Abdul? Respondent, which one?
Respondent, my lord, here in this case, who was the plaintiff in the title suit,
Abdul Motleb Mia.
Faisal Haq Mia, son of Abdul
Haq Mia.
Matleb Mia. He is the plaintiff.
He is the plaintiff.
He purchased a plot of land measuring 1 biga from Afzal Khan. Not Sabzal Khan, your lordship. Sabzal Khan, the original owner of the land. And now in the year 1983, and my father, late Nazrul Islam, while he was alive, he purchased 2 biga 3.5 kata land in the year 2011 by registered sale deed.
Who purchased?
Father of the appellant, Nazrul Islam, in the year 2011 by a registered sale deed from the son of this original.
Now these appellants are all sons of Nazrul Islam.
Yes, lordship.
He purchased the land in 2011 and that
2011.
and purchased the same land in 1983.
83. Not same land, but out of total land, 6 biga 7 lessa. Total land consisting 6 biga 7 lessa. Out of 6 biga 7 lessa, 1 biga purchased by the respondent in
What
their
biga?
in their 1986. 83.
No, no.
1983.
Plenty purchased land. How much land?
1 biga measuring.
Plenty purchased.
Purchased.
How much this Nazrul Islam purchased?
Nazrul Islam purchased 2 biga 3.5 kata. 3.5 lessa. 2 biga 3.5 lessa. I have narrated, your Honor Lordship, in this case.
Out of the same 6 bigha land.
Same biga. Out of 6 biga 7 lessa. Same
6
dak.
biga, 7
Same
lessa
dak,
land.
same patta.
From that, what is his, what Khan, what is his name? I forgot
Now-
his name. What is that vendor's name? I have forgotten. his name. What is that vendor's name? I have forgotten his name.
My Pahar Kha is my vendor.
Pahar?
Pahar Kha.
Pahar Khan.
Pahar
No.
means hills.
Okay. Pahar Khan. okay.
Pahar Kha. Pahar Kha is the son of original owner, Sabzal Kha.
Yes,
Sabzal Kha is the original owner in lordship. And during the lifetime of Sabzal Kha, this respondent purchased 1 biga. He is the first purchaser. The respondent is the first purchaser from the original owner, Sabzal Khan
But
Abdul
you
Khan.
just told me plenty purchased the land in the year 1983 and respondent in the year 2011.
Yes, but we purchased. That my father purchased in the year 2011, 2 biga 3.5 lessa.
Or purchased
From the son of the original owner, Pahar Kha. Pahar Kha is the son of Sabzal Kha.
and plenty purchased in the year.
From the Sabzal Kha, 1983,
How many bighas?
1 biga. From the same plot of land, out of total land, 6 biga 7 lessa.
Okay, now I got your point.
This is the factual background of this case. Now, what happened when we purchased the land from the son? Because when this original owner, Sabzal Khan, demise, then
Paharkha, my vendor, got mutation on the basis of right of inheritance. Now, after perusal of the record, my father entered into agreement with this Paharkha. And thereafter, what register sale deed was executed. And after proper verification, as per our position, mutation also been allowed. Our name also recorded thereafter. The appellant here, after demise of my father, Nazrul Islam, our name also been recorded.
Yes.
But till today, the respondent name has yet not been recorded. This is the case. Now, the learned trial court, but the court committed mistakes by not issuing our portion, Exhibit Kha. Exhibit Kha is our land, and that is, your lordship, find here, my lord, page 44, the judgment, the decree and judgment passed by the learned court below, entitled suit number 73, 2014. Here, page 44, our pleading has been recorded. Paragraph 24. Page 44, paragraph 24. May I go it?
Yes.
From the pleadings and oral evidence of the defendant, it appears that the defendants have admitted that the original pattadar of the suit land were Sabjal Kha and Haran Kha, these two brothers. Pahar Kha inherited the land of Sabjal Kha after his death and sold 2 bighas 3.5 lesa land inherited by him to Nazrul Islam. Nazrul Islam is my father. The father of the main defendants, by executing registered sale deed number so and so, dated so and so. But regarding this contention, no issue frame. And thereafter, our name also, my father's name also mutated, and after demise, our name also been mutated as the right of inheritance. That not issued, and no any issue frame, and that have been overlooked. So subsequent purchase, but quite different land. 2 bighas 3.5 lesa. So can it be relinquished or our right title? That is the issue in this case, and substantial question of law. I have narrated your lordship. That is the substantial question of law. I have narrated number of. This is the main substantial question. Lordship, kindly have a look, page 4 of my appeal memo. This is the sole issue because our sale deed exhibited before in the trial proceeding, and that has been admitted, no disputed arise, and thereafter mutated, recorded on the land record, and that also not disputed. How our right of inheritance and can be extinguished because of only second purchaser, but quite different proportion of land, different boundary, 2 bighas 3.5 lesa.
Have you annexed the sale deed?
Yes, that is exhibited, your lordship. That is in the judgment. It is clearly mentioned. Paragraph, my lord, page 45. 45, paragraph 27. The defendants have produced the registered sale deed so and so, which is exhibited as Exhibit K. But it is undisputed. No any question also put before me when I was cross-examined, whether it is fact or something else. Nothing. It is genuine. Only observation made in what the court below, that I am the second purchaser. That cannot be ground that my right title and interest shall be extinguished. This is the case, your lordship. So, well, notice may go, and so far my substantial question as well as ground narrated in the appeal memo. So all this substantial question also be quote and notice may go. Very fine, it's a good case in favor of this present appellant. We have a registered sale deed and also been recorded, and respondent name has yet not recorded. Now, respondent claim in the title suit 53 page 53, the schedule B, that is only measuring 1 biga of land.
No, no. You see, moreover, exhibit K is executed subsequent to execution of exhibit 3. The evidence on record reveals that plaintiff was in possession of the land until he was dispossessed by the defendants on 11/2/2014. It is not disputed that the plaintiff was in possession of the suit land after execution of exhibit 3. The boundary is also not clear.
Not that is contention of the plaintiff.
No, it was
Plaintiff
completely-
purchased in the year 1983. From 1983 till date, could not able to make entry in the land records. My boundary is quite clear, my lord. I have not annexed here, my lord. This is my boundary.
No, it has to be annexed.
My lordship.
It has to be annexed.
No, annexed is on record because it is written
But
in
it has been held concurrently, you see.
no, that is on record.
On perusal of exhibit K,
record-
it appears that the boundary of the said land is not specific.
No,
Exhibit K.
it is clearly specific. Kindly have a look, lordship, for a moment. It's specific. Exhibit K, I am not telling lie, because exhibit K is there. And record itself will reveal the fact. Exhibit K is there. So all this LCR will reveal the entire facts. It is not disputed.
What about TA? What about the TA? Title appeal?
Title appeal, the affirm, my lord, this,
Yes, that is why I'm saying.
judgment passed by the cell deed, title suit. Title suit judgment has been, my lord, therefore the second appeal. Therefore, the second appeal, I am before this one report. And here, my lord, operative portion,
No, that boundary is not clear.
the
we-
judgment and decree
Land
dated,
number and pata number is mentioned. Boundary is not clear from exhibit K. Only
Boundary-
lot number and pata number and the said land is mentioned.
Chauhat, you know, Chauhat, clear, Chauhat is there. Chauhat is bounded.
There's no sword.
Chauhat is there, your lordship.
No,
Chauhat is below portion. Chauhat is there. So our purchase land is not disputed. Only here judgment also saying the trial court judgment only saying that
what mentioned in the Sohar, Uttare and Pube, bus. No more than that.
and here is saying that paragraph 27, page 45, the moreover exhibit K is executed subsequent to the execution of exhibit 3. Exhibit 3 is the purchased land of respondent. The evidence on the record reveals that the plaintiff was in possession of land until he was dispossessed by the defendant on so and so. It is not disputed that the plaintiff was in possession of the suit land after execution of exhibit 3. Thus, it is clear that in fact legal heir of Sabzal Kha did not inherit 1 biga of land from the original owner, as the original owner Sabzal Kha exhausted his title over the said land by selling to the plaintiff by exhibit 3. But I am not interfering so far 1 biga land is concerned. My purchased land 2 biga 3.5 lesser. I am in possession. So if 1 biga land possessed by the plaintiff, here is respondent, I have nothing to say. But so far my possession is concerned, my sale deed is concerned, my father's sale deed, registered sale deed, and so far mutation is
No,
concerned.
sale deed is
That
okay.
is
I'll
not
tell you what is in the Sohar. I'll tell you.
that is not challenge.
Uttare, so and so, Pube, so and so, bus. No Dokhin, no Paschim.
Dakshin Pashchim Nani.
Nai, Dokhin Paschim nai.
But question is our sale deed, whether it is void, illegal,
What is the
ha-
substantial question of law?
that has not been challenged. Substantial question of law, second parcessor, being a second parcessor and separate plot of land, can it be here, page 4, your lordship, substantial question number 4, can it be extinguished our right, title, and interest? We purchase the land, this is the valid sell deed, registered sell deed, and thereafter mutation also there. So second purchaser, but separate plot of land,
Mutation, it will always be there.
but separate
Even
plot of
for
land.
Purchase also
But,
it will be
but
mutated.
sell deed cannot, has yet not challenged. It is a genuine sell deed. It is not fact. This is genuine sell deed and no question were put that it is a fabricating or fact. Nothing is there. It is admitted fact that sell deed is genuine. If genuine sell deed is there, so on the basis of sell deed, my right title cannot be extinguished. This is the substantial question of law. The Honorable Supreme Court also says that entry on the land record cannot be right title come. But so far, registered sell deed is there. That is the valid document. That is the base,
The
foundation.
sale deed, I had seen just now your sale deed, and that courts also have held that the boundary is not clear.
Lordship, I am coming to the sell deed and because of the pro forma defendant son
And
sold the property
they had purchased the land earlier to you.
from the
in
father of the pro forma defendant. I purchased the pro forma defendant Paharkha and they purchased 1 biga from the father of the Paharkha. And after demise, right title goes to Paharkha as a inheritance. And Paharkha, on the basis of this is right title and possession, he sold out this land and we purchased after verification of the land and we purchased, we are in possession. We are in possession so far our title suit is concerned. Our this sell deed is concerned. We are not encroached respondent property. We are not encroached so far the suit property is concerned. Suit land, my lord, here page 55 is quite different. Suit land, lordship, page 55 in the title suit, saying an area of land measuring 1 biga land within 4 biga 3 kata 7 lessa land covered by dag number so and so 660 and periodic patta number 122. But our land having 2 dag number. Our land, lordship, having 2 dag number, but patta same. But this our land cannot cover the plaintiff land. Quite different portion of land. So our land cannot be disturbed because we have a valid sell deed. And that sell deed is still enforced, has not been assailed. But only condition that from the son we purchased and they purchased 1 biga from the father. And it is my lord, genuine fact, my lord, when father demise, ultimately son will get the inheritance, right title.
There are so many questions here. The son will inherit the land, then land has to come, partition then come under his possession, then he will be able to sell.
No, we purchase from the son.
Yes.
When the
Son after father's death,
after getting inheritance,
after
son.
father's death.
Yes.
Son will inherit the land.
Yes.
5 sons or 6 sons.
One son.
Only one son.
Sobjol Kha having only one legal heir,
Okay.
the Paharkha.
You are 5 sons.
Yes. We are son of Nazrul Islam. Nazrul Islam purchased from only legal heir, Paharkha. And Paharkha also adduced evidence and has not been cross-examined.
But this is the same land, see? The suit is decreed and the same land. You are saying it's a different plot of land.
But
Decree,
schedule,
in that
my lord,
decree,
but
it is mentioned, dag number, dag number 60, patta number 122. Then
yes,
village
but
Banduri.
our land having 2 dag number, my lord. But plenty land, my lord, only one dag number, there is 60 under patta number 122.
Oi patta 258.
Yes, having two dag numbers.
Schedule A land, an area plan measuring 4 bigha 3 katha, that is the plaintiff's land.
Yes,
Uh,
that is the original owner's land.
plaintiff.
Original owner's land.
No, no. Plaintiffs have stated joint title interest of plaintiff defendant and the pro forma defendants. So plaintiff is saying that a part of the land is their land also.
Lordship, page 55, the schedule B clearly, the schedule B is the suit land. Page 55. An area of land measuring 1 bigha of land within 4 bigha 3 kata 7 less of land covered by dag number 60 under periodic pattern number 122 of village Bandharia. And our schedule land, page 60. Page 60 in the WS, it clearly narrated.
Plaintiff has stated that they want right title interest and a declaration that Schedule B land is a part of that Schedule A land.
Yes, it clearly mentioned, Your Honor. Schedule A. Schedule A is 4 bigha 3 kata 7 lesser. And B is the schedule land is B.
Decree.
Suit land is B and B land is already decree.
You see the decree? The decree you have annexed with me.
Yes.
Annexed in the RSA.
Yes. Title in the title suit, decree is there. Page, my lordship, 46.
The decree includes Schedule A land.
Plaintiff is entitled to permanent
50
injunction.
page 50 is the decree.
Yes.
The,
Or
the
46.
decree includes Schedule B land within Schedule A land. You cannot say it is separate. That is what I am trying to point out.
Yes. Schedule A and Schedule B quite different land.
No,
And
no. No, the suit was decreed
yes.
that Schedule B land is inclusive of Schedule A land. We'll fix it for another date.
No, Schedule B, lordship,
You will fix it for another date.
No, plaintiff is entitled to permanent injunction restraining the defendant from disturbing the peaceful position of the plaintiff over the Schedule B land.
And every word.
Schedule B land.
We'll fix for another date.
That doesn't matter, but the question is, it is clear case.
Let us fix it for another date after puja vacation. Do you want to stay? Do you want to stay?
Yes.
After puja vacation, then we'll fix it for another date after puja vacation.
But how my lord, I am surprising because it is clearly mentioned Schedule B and Schedule B land measure also saying Schedule B also measuring 1 bigha.
Repeatedly stating that this is different land. I have
Covered by dag number 60, patta number 122, and our land, my lord, here, so far pleading is concerned, record, we cannot go beyond the record. Record saying our land is, my lord, 1 bigha, 1 katha, 3.5 lesa, and dag number 60, so and so, and dag number also 258, and patta number 122.
Do I reserve it for order or should I fix it for another date?
Another date is not satisfied today.
Before vacation or after vacation?
Before vacation. Before vacation.
Then next week.
Date may be fixed.
Yes. List this matter on data video. 24th September.
Obliged.
Supplementary for this item 43. A mullah, he to understand.
Lordship, that matter has already been heard by your lordship. So if
Fix it for another date.
lordship,
Yes.
if you want to rehear it another date
Yes. After vacation.
before vacation, if
What is the urgency? They're staying there. What is the urgency? List this matter after Puja vacation. I've read everything.
lordship,
I took it home and I've read it.
lordship.
Item 28 for orders.
May it please the Lord. On last occasion also, my lord, the appellant remained absent.
Hmm.
And appeal, my lord, is of 2013.
Oh, applicant is always absent.
On 27/11/2014, lordship.
22/4/2024, different order was passed.
And in IA, my lord, it was recorded in IA 1655.
Last order 22/4/2024.
No, thereafter, my lord, 27/11. In IA, my lord, 1655.
27/11, okay.
Lordship.
Okay, then we'll club all this together and fix the last date. And then we'll dismiss it
Lordship.
if they don't turn up. Because in appeal, it was last date was 22/4/2024.
And lordship.
Green club को ही लिखी दिया. Appellant is absent without steps. Learned counsel Mr. R. Ali is present. Please, the final opportunity is accorded to the appellants on on absence leave. On absence of the appellant on the next date fixed from this appeal, necessary orders may be passed in this appeal.
Lordship may record their absent, earlier absent also, my lord. It will be clarified.
Given. Appellants were absent on 27/11/2024 and appellants are absent today on 2 consecutive dates. List after puja vacation.
In date, my lord, kindly. Yes,
Date?
2013 matter, my lord.
Okay. And there's no stay also against you.
No.
16th October.
Obvious.
Item 29. Yes, yes.
There are 3 IAs, my lord.
Mm.
Your lordship will see the last order.
Mm.
The respondent is absent.
Which one?
Respondent side. The last order, your lordship will see.
Which one?
29.
IA number 29.
No, no, my lord. Last order of your lordship.
On the first IA.
Yeah.
IA number 82.
No, no, your lordship has passed the order of.
29/8/2025. Yes, sir.
Other side is absence, my lord. There is a petition, 82.
Oh, I have only passed over.
82, 83 and 85.
Okay.
82 is my lord limitation. There is a delay of 16 days, my lord. Because the death was not informed to us. Later on, we came to know that he died. So we have stated everything herein that why it was delayed, my lord. Because the petitioner also not aware of the legal proceeding. So there's a delay. So if your lordship on the delay, then it comes, my lord, order 27/9, my lord, for abatement of the present suit and then substitution of the respondent number 5. my lord. Then only the hearing can take place. Because the plaintiff has died.
IA number 82, 2018, Learned Senior Counsel Mr. M.K. Mr. K. Bhattacharya is present for the applicant. Respondent number 1, 5, 6, and 7 are not represented today. What about 2, 3, 4?
Well, they are not interested. As for the office court, my lord, all the notice has been served except respondent number 5.
Okay.
Earlier they have appeared, my lord, then they absent.
No, 5 to leave or something. Yes, I don't.
Your lordship will see 21/10/19 order.
Okay, respondent number 5 has appeared.
Yes.
1, 5, 6, and 7. I'll just go behind and check about the other 2 respondents.
Yeah.
We have 1, 5, 6, and 7. 2, 3, and 4 we do not have before us. 2, 3, and 4.
So as per the office note, they have
I'll
appeared.
check the office note.
Yes. That will also.
If they have received and they have not turned up, then I'll pass the order.
Yes, my. His name was stuck off, my lord.
Okay.
Name of the petitioner.
Service report received on the respondents have been placed here with service report 1, 3,
1, 3, 10.
but no service report on respondent number. So 4, there's no service report.
No, no, there's no substitution.
So you'll have to issue notice on respondent number 4.
Yes, my.
I think so. It will have some office note dated way back on 1/10/2018 indicates that respondent number 3 has
Expired. Stuck off, my lord. As per the Honorable High Court's order dated 9/2/15.
9/2/15.
Yes, the respondent number 3 name was stuck off, my lord.
9/2/15.
Yes,
It will
9/2/155. That order. Stuck off.
9/2.
9/2/2015.
This is 2018's case, I think.
No, no, this is 11 case, my lord.
Okay. Nine to 2015. Okay. As per order of this court in RSA 47/2011, dated 9/2/2015, the name of respondent number 3 has been struck off from the records.
Yes. Even 10 also, my lord, but 10A, 10B, my lord, this is also by the Honorable Court's order, my lord, dated 10/5/12 and my lord, 10/5/12, my lord. 3, 10, and 14, my lord.
When?
It was by Honorable Court's order, my lord, dated 10/5/12 and 11/12/14.
So stop this court's order dated 10/5/2012 and
11/12/14.
11/5.
11/12.
11/12.
14. Yes.
14.
Yes.
10/5/2012.
10/5/2012.
12.
T, 10, and 14. The stuff of my food.
In which case we do not have in the RSA.
In RSA.
Not in RSA.
These are the legal heirs, my lord. These are the legal heirs of the Masammat, Muzamil, Nasa, and all. In the RSA, it is there, my lord.
No, it's not there in the RSA. 10/5/2012, no order in the RSA.
Ah. No. Yes, my lord, this is in the RSA, it is there.
10/5/2012.
9/2 order, our High Court's order is 9/2/15 for respondent number 3.
9/2/15.
Yes.
9/2/15.
Yes, respondent number 3, Masammat Saikhani.
That I have
Yes.
recorded.
Then your lordship will come to the 10. Nisa Khatun, my lord. Yes.
That is there, my lord. Or that is order dated 10/5/12.
No, there's no order in this RSA.
But,
512. Maybe office note, let me.
No, in a miss case, my lord, 2309.
2309.
Yes, yes, it's a miss case.
Okay.
MC number.
I'm checking in the
Yes,
RSA.
yes. No.
Okay, Lisa. This course, no, but two sons of, okay, respondent number 10. This is okay.
Okay, that's.
This is legally has been implemented, it's okay.
Yes, yes, fine. We stuck up with the name, but they have included.
Legally
Yeah.
has been implemented, it is there in this case.
Yes, yes.
82.
Yes.
So,
But
and
none
what
of
about
them-
the other respondents in 82?
None of them appeared. In spite of the notice, none has appeared.
Notice has not been served actually. Only one, 4 and, okay. 10, 12 and 13.
But-
AD cards received 10, 12 and 13.
The advocate and.
1, 6, 7, 10, 12 and
The lordship
13.
will just verify the Vakalatnama, my lord. That will make it clear, my lord. I think so. Of the opposite party. From the office report.
The Wakalat no check person. A to all of Mila ideas.
No,
Respondent to 3 to go. 1, 3, 6, 7, 8. এইখিনি চাবাচোন দেই অফিচ কোনখিনি এপিয়াৰ হ'ল কোনখিনি নাই হিচাপ দি দিবা
My lord, respondent, it is says the advocate DK Deka, NS Borbuya, and others. They have appeared, my lord. They have filed a
Item number-
Vakalatnama. Yes,
What is this item number?
29. Because they have appeared.
মিলাই চাচোন call list লগত মিলাই চাওক we'll just check if all are represented we'll pass an order
But okay, your lordship.
after some time
Okay.
cause on this
After some time, my lord. Poor already.
we'll just check and we will see who have appeared and who have not then we'll pass an order
Okay.
if they have received notices and they have not appeared I'll pass an order
Okay.
I condone the delay
And admit for the hearing outside.
I'll just check
Okay. So I will take the lead.
but if they have not but
Appeared, then notice will be put.
yes then I'll
Then-
pass an order for
Oh,
notice
yes, yes.
In this case, my lord, steps upon respondent number 36 was taken by register post. Usual course was not taken. So, my lord, 7 days time may be granted to ask.
Learned Counsel Mr. R. Ali representing the appellant is present to stop. Notices may be issued to respondent number who?
36, my lord.
Respondent number 36 as per usual process returnable within 4 weeks.
Okay.
List accordingly. Item 32.
It's a transfer petition. They have filed transfer petition for transferring the record from Dibrugarh to Sibsagar. My lord, we have no objection, madam. Kindly discuss the board.
From which court to which court?
District judge.
District judge Dibrugarh to the court of district judge Sibsagar. Sibsagar, you have no objection.
No objection.
Learned Counsel Miss R. Begum is present for the petitioner, for the applicant. And file this application under section 24 of the CPC for transferring title suit D number 103/2024.
Yes, ma'am. Divorce petition.
From the pending in the court of the Learned District Judge Dibrugarh to the court of the Learned District Judge Sibsagar. Learned Counsel Mr.
C Chakraborty.
C. Chakraborty is present for the
For
respondent.
respondent, sole respondent.
Sole respondent and has stated that he has no objection if the case is transferred from Sibsagar, from Dibrugarh to Sibsagar. As I've considered the submissions at the bar, why this case is required to be transferred?
Because there is a distance, my lordship, he is an.
The distance issue is there, ma'am. Petitioner is stating that distance because of the 70 kilometers
72
from
kilometers.
our place.
He has no source of income, my lordship.
It is submitted that it becomes difficult for the petitioner, being a woman, to travel from Sibsagar to Dibrugarh to to appear in the proceeding, and she is a woman with no income. First of considering all aspects and considering the submissions at the bar, the proceeding the entire case of title suit D number 1303 of 2024 is transferred from the court of the district judge Dibrugarh to the court of the court of the district judge Sibsagar. Title suit to likhi as a number to under section likhi diba 13 under section 13 within bracket 1 within bracket small 1 arrow small a bracket close and within bracket small 1 small b bracket please. In terms of the above observation, this petition stands disposed of.
Item 33.
Yes, please, Your Lordship. In this, as per office law, Lordship, respondent number 125 entered appearance in the filing Mahalama, Lordship.
I have also filed objection to the my lord condemnation petition.
And so far is respondent number 6, Lordship, answered notice of has been received back with postal remark insufficient address. And ID card and of the respondent number 7 has not been yet received, Lordship. In this, what happened, Lordship, in this, this is the MSc appeal filed by Lordship earlier contacting council BK Portputa as the Lordship. But subsequently he left Guwahati, Lordship, and go to Delhi. Now he is resigning, but he has not handed over the brief to the insurance company, Lordship. So they have no knowledge. Accordingly, the case is dismissed for default, Lordship. I have filed a miss case for restoration, and there is a 19 days delay for this, Lordship.
What about the appearance of the other respondents?
Other respondents, there are also, Lordship, none appears on the in MSCT court also, Lordship, ex parte, Lordship.
Okay.
I have my full objection only because the judgment was passed in on my 23/4/2018, my lord. 7 years already gone by, my lord. Not a penny has been received by the claimant, my lord, on date of their.
Insurance company has no fault, Lordship, that earlier contacting council, Lordship.
And
He
the
has not-
condemnation petition, they have not explained the delay, my lord. Vague allegation against one advocate, my lord. He is not a party to the proceeding.
He-
Not a letter has been, my lord, annexed with the, my lord, the condemnation petition.
He left the place, Lordship. Now he is in Delhi, Lordship, with her.
How can we say, my lord, who is required, my lord? Not a
19 days delay, Lordship. there is
Personally,
nothing-
matters, my lord. 7 years gone by, my lord. There is no explanation in the condemnation petition. Even for 1 day, well, delay must be explained, my lord. There was not there, my lord.
Explanation is like
It's not that the condemnation is automatic, my lord.
19 days delay, Lordship, Lordship. In paragraph 3, Lordship, other than that, the Youngest Council BK Purtas, Lordship, he is a panel advocate, Lordship, preparing this MSc appeal, Lordship. Accordingly, he has filed this case, Lordship.
Para 4, my lord, kindly read the, my lord, condemnation petition.
Youngest Council left Guwahati and did not.
When he left, my lord, how he left, my lord. And they have said, my lord, they,
And returned and.
he has returned all the records to them, my lord.
Except
But only the present case was not handed over to the insurance company. That is not acceptable.
Otherwise,
Okay,
Lordship,
okay. We
on
wanted
behalf
the
of the.
delay.
Yes,
Learned Counsel Miss
D.D. Burman, Lordship.
D.D. Burman is present for the insurer,
Yes, Lordship.
and Learned
Happy
Counsel
Lord,
Mr. P.J.
My lord.
Soikia is present for the claimant.
Claimant 1 to 5, my lord.
For the claimants. This application has been filed under Section 5 of the Limitation Act 1963 with prayer for condemnation of delay of 19 days in filing the connected MSc appeal number
No.
137 2023, which was dismissed.
In filing the restoration appeal.
Or in filing
The restoration.
Restoration petition was also dismissed, my lord, earlier, my lord. Therefore, this petition was filed for restoring the case. It
in
will
filing
ultimately,
15 days delay in filing the application for restoration of MSc appeal number 137 of 2023, which was dismissed on 21/2/2024 for non-prosecution.
Yes, Lordship.
The learned counsel for the claimants has raised serious objections stating that the claimants are suffering owing to the 7 years delay
yes, my lord.
in receiving the compensation, full stop. The claimants have also raised objections stating that the reasons of delay has not been properly explained, and thus as no sufficient grounds have been shown, the petition ought to be dismissed. The learned counsel for the applicant has submitted that the earlier engaged counsel has left Guwahati and did not continue with the proceeding, which resulted in the delay. Full stop. There is no malafide on the part of the applicant. After considering the submissions, it appears that there is no malafide on the part of the applicants. Considering all aspects, delay is condoned. The MSc Appeal number 137 of 2023 is to be restored to file. 137 over 2023 is to be restored to file. Okay. In terms of the above observation, I stands disposed of. Our MSc appeal to Lika, both the parties are represented.
Another MSc appeal lordship for restoration.
Now I do restore to file for Baki Bukora. List this matter after puja application.
Yes,
My lord, immediately after.
yes, sir.
My
You
lord,
want a date?
my lord. 8 years gone by, my lord.
Yes, date at a video. Date at a video. List this matter on.
Apply the law.
Apply. Apply.
Oh. It main case of today. Both the parties are represented. This case is it will do no. After restoration only we can give the door.
Lordship,
No, it we'll have to restore the file.
list the matter
Register has to,
in the next week.
we'll have to mention it. Register has to restore to file, yes.
Yes.
It'll cut it here.
Wait, please, Your Lordship. As per office note, Your Lordship, service is awaited. I may be granted 3 weeks time to take steps by usual process.
If learned counsel, Mr.
MH Loskar.
MS Loskar is present for the applicant. Service report on respondent, how many respondents?
Two respondents. 1, 2, 3 respondents.
Service report on respondent is awaited. Applicant may take fresh steps. Applicant may also take fresh steps to issue notice to the respondents.
By usual process.
By usual process, returnable within 4 weeks, this accordingly. Okay.
Obliged.
Item 35.
May I please, Your Lord? My lord, as per office note dated 10/9, my lord, the answer notice has not been received. And in the meantime, my lord, usual process is not taken, my lord. That I will be allowed.
Service report on respondents is awaited. List this matter after 4 weeks. Fresh steps may also be taken by the applicant. If you want to take, it's up to you.
My lord, upon the sole respondent,
Yes.
that may be indicated because
Upon the sole respondent.
obliged.
Item 36.
Please, Your Lordship. Lordship, this IA is seeking for condonation of delay for 4 days.
How many?
My lord, for 4
The 4 days delay, my lord. I am appealing respondent number 1, my lord. Respondent number 2, my lord. Regarding respondent number 2, my notice has not been served, my lord. The respondent number 2 has never, my lord, contested in the trial court, my lord. Expert was, my lord. And my lord, regarding item number 39, my lord, out of the same incident, my lord.
39.
There is a report, my lord, that no such person is living in that area. There is a my lord, certificate issued by the government. My lord, this respondent number 2 has been struck off, my lord, and delay may be continued.
You want respondent number 2 to be struck off?
But in item 39, there is a report, madam. Out of the same incident, madam.
Who is respondent number 2?
This is a driver, madam. He has never contested in a trial proceeding also, madam. Both the cases, madam. So, madam, it would be unnecessary delay.
Learned counsel, Mr.
M. Raman.
M. Roman is present for the applicant and learned counsel, Mr. Khonikar, no?
Madam. A.
Khonikar is present for respondent number 1. Service report on respondent number 2 is awaited. Who submitted that the respondent number 1 did not contest the proceeding.
Respondent 2.
Oh, yes, respondent number 2 did not contest the proceeding.
Trial proceeding.
before the tribunal, the learned counsel for the respondent has no objection if delay is condoned. It is submitted on behalf of the applicant that there was no malafide on the part of the applicant. Why couldn't you file the appeal in time?
Due to health issues.
It was submitted that owing to health issues, application or appeal could not be filed within the period of limitation, considering all aspects. Delay is condoned, registry to register the connected appeal.
Not showing my name, my lord, in the cause this matter.
Oh,
Others,
you live there in the course.
Not in the, I am my lord. But in the appeal may not be my lord reflected. My lord.
I am disposed of.
No, and that is my lord, when my lord appeal is listed, my lord, will be listed, my lord, that my name is.
Okay. The name of the learned counsel for respondent number 1 is to be reflected in the cause list.
You also taken up to 39, my lord.
39 to details make a correct reading.
My lord, there is a small problem, my lord, in the item number 39, my lord. My lord, respondent number 3, my lord.
Hmm.
His name was wrongly, my lord, recorded in the judgment, my lord. Subsequently, I have corrected, my lord. Please, my lord, kindly have a look, my lord. This is the order passed by the, my lord. His name should be, my lord, Jitu Gogoi instead of Devot Soike, my lord. Jitu Deori, my lord. Okay, no,
That's
Jitu
number
Deori.
3.
That's not three. It should be Jitu Deori instead of Devot Soike.
You'll have to correct it.
Oh, my lord. I have subsequently corrected the, my lord, petition has been filed before the, my lord, decisions and subsequently it was corrected. And I will, this order, my lord.
Or then you have to file an application here.
Already I have filed, my lord, corrected, my lord. Now, my lord, this petition has been corrected, my lord. This will be corrected by him, my lord, not.
Okay, okay, he has to correct.
He has to correct.
You correct it, then we'll pass an order for condonation of delay.
My lord, due to this, my lord, name, my lord, dispute, my lord, I could not appear, my lord. Otherwise, I will appear, my lord.
You'll have
On behalf of him.
Let's correct it. Okay. Release this matter on next week.
Next, my lord, both the cases, my lord, maybe take 2 minutes.
They don't know, that will go for listing. This is matter on 21st September.
Well, I need the copy, my lord.
Yes, you'll take it back. Did you copy? You did it.
Deep knowledge.
Item 37 and 38.
Legal lordship. Also, there is a delay of 19 days in filing the RSA lordship. However, they have the objection stating that the 19 days delay should be of 25 days, your lordship.
It was their calculation. Can you see the delay condom petition?
19 days, yes.
No, they have written it 19 days,
But it is 25 days.
but it is 25 days.
But the lordship,
Their explanation we left it for 6 days delay. They have not explained.
but lordship,
anything.
the delay that has been counted by registry also, your lordship. Lordship may peruse the appeal memo. The first place, the delay has been categorically explained, your lordship.
Appeal memo is not.
In
Yeah.
here, your lordship.
Heard learned counsel,
As
Mr.
Gautam, your lordship.
As gotten for the applicant and learned counsel, Mr.
B Fukon.
B.
B Fukon.
B. Foucault for the respondent number.
All the respondents.
For the respondents, okay. For the respondents. It is submitted on behalf of the applicant that why there was delay of 19 days?
My lord, the reason of delay is, my lord, because the appeal memo, the order of appeal was given on 27/2024. And after that, sorry, my lord, the 7/6/2024, your lord. Then after the appellant went to the council, to chamber, to the council
That
chamber.
the judgment was the judgment in judgment and decree
Yes, your lordship. 34/2024 and 7/6.
in title appeal number 23 of 2023 was delivered on
34 and 7.
34 2024 and 7/6 2024. No.
Hmm.
No. Judgment and decree was delivered on 15/7/2024.
Yes, Lord. Yes, Your Lordship, 15/7/24.
Okay, now the applicant disclosed state after getting the information and dated. No. Where is the judgment and decree? With title appeal number. On 30/4/2024. On 30/4/2024. N nalage, huh? Full stop. It is submitted that as certified copies which were applied for were received on 28/6/2024. No, received on say 15/7/2024.
15/7/24.
On 15/7/2024. Full stop. The applicants came to Guwahati on 27/2024 and met the learned counsel. And there was a delay in preparing the appeal memo. Full stop. On the other hand, the learned counsel for the opposite parties has raised objections stating that the delay has been erroneously referred to as 90 days as the delay was for 25 days and not 90 days.
19.
25 days and not 19 days. The reasons have not been shown. Full stop. The appeal or the application ought to be dismissed. I have considered the submissions at the bar. No malafide is discernible on the part of the appellant. Full stop. Considering all aspects, it appears that delay may be condoned.
If he is not explaining the 6 days delay.
No, I have not given the subject grounds shown. I have not noted down. Only malafide is not discernible that much. Delay is hereby condoned. In terms of the above observation, this application stands disposed of. They have not shown good grounds. That's why not recorded. Grounds have been shown, but not malafide is not discernible. Register to register a connected appeal. Appeal to register koi petition or appeal?
Appeal, Your Lordship.
Appeal.
Petition has been filed with him.
A petition is filed by.
Item 29 is
Oblige, Your Lordship.
Oh, acha. Oito pass koi din. Pass bit of koi din. Nine no manu. Hey, kubol digda hobo. Silo pela mo koi din.
Oblige, Your Lordship.
Item number 40 for hearing.
40, no point hearing today.
Not, I would not insist for it. Let it be fixed on 4th November, my lord.
Luckily, the appellant is not present.
Yes, he is also not. On twice earlier, he was also not present.
Huh?
On twice
Earlier,
occasions, he was also not present.
earlier also he was not present.
Yes.
The appellant is not represented today. Learned counsel for the respondent, Mr. O.P. Bhatti is present. A last opportunity is accorded as this is an old pending case. List this matter positively for hearing on date of the
On 4th November.
4th November. On absence of any of the parties, this case will be decided on merits.
Noted.
Bitot di diba mo kodi.